They have cell phones, they should be on silent.
Okay, let's see. I'm going to call the cases where the plaintiff is represented by Attorney Cox first. Is Attorney Cox in?
No, that's Attorney Rude.
Oh, okay. Okay, we're starting with Attorney Rude, I'm sorry. So I'm calling the cases where the plaintiff is represented by Attorney Rude. Attorney Rude, you have a significant portion of the docket. Let me see, 1, 2, 3, 4, 5, 6. So I'm gonna call half of the cases first and then I'll call the other half, okay? So I'm going to call the cases. Please listen out for your name, address, or case number and try to step up in the order in which I call you, please. Okay, now calling case number 23348-955, Alter Chalmers LLC versus Edwina Sykes and all occupants of 14414 Corbett D107 in the city of Detroit. Also calling case number 23348-956, Alter Chambers LLC versus Lachey Smith and all occupants of 9441 Queen C106 in the city of Detroit. Also calling case number 23348-957, Alter Chalmers LLC versus Sherry Anderson and all occupants of 14414 Corbett D106 in the city of Detroit. Also calling case number 23348-958, Alter Chalmers LLC versus Charnel Ross and all occupants of 9441 Queen C206 in the city of Detroit. Also calling case number 23348-959, Alter Chalmers LLC versus Paige Hudson and all occupants of 9441 Queen C203 in the city of Detroit. These matters are before the court on complaints for non-payment of rent and complaints to recover possession of property. May I have plaintiff's counsel place your appearance on the record?
Morning, Your Honor, Brian Reed,
Thank you. Good morning to you, Attorney Rude. Ma'am, what is your name?
Charnel Ross.
Charnel Ross. Okay, good morning to you, Ms. Ross. You are the defendant on matter ending in 958, and you are before the court on a complaint to recover possession of property. Ma'am, are you two together? No?
We friends, but we got different apartments.
Okay.
Paige Hudson.
What's the,
What? Paige Hudson.
Paige Hudson? Okay, let me see.
Hi.
Thank you. Ms. Paige Hudson, you are the defendant on matter ending in 959, and you are here on a complaint to recover possession of property. Okay. This is the first hearing scheduled for these matters. Pursuant to Michigan Supreme Court Administrative Order 2020-17, all first hearings shall be adjourned. So these matters are going to be adjourned to another court date. The next court date for these matters, and I'm talking to you two, Ms. Hudson and Ms. Ross. The next court date for you will be June 28th at 9:30 a.m. Have you all had an opportunity to speak to an attorney today? Okay, so you do have the right to be represented by an attorney. You can either hire your own attorney or you can speak to an attorney from our legal services agency. They are in room 417, correct? And so if you haven't had an opportunity to speak to a defense attorney today, at the close of today's hearing, I'm going to ask you to go into the hallway to wait on your paperwork and then go to room 417. If you've already spoken to an agency attorney, then you're free to go once you get your paperwork. Attorney Wu, I don't have the proofs of service for these files. Do you have the proofs of service?
I believe the court officer had filed them. I'm showing. Posted on June 6th.
Well, it's not really, I mean, they're here. I'll move to the other matters in a moment. I just need you to file those if you haven't already done so, by the next court. Thank you. By the next court hearing.
Your Honor, I did have a chance to speak with both Ms. Ross and Ms. Hudson about conditional dismissal of the about date. I don't know if that's something you want to discuss or.
I mean, if you all, have you all spoken to, have the agency attorneys assisted you with coming to terms of a conditional dismissal?
Yeah, he talked to us, he gave us a date that we could move by.
No, he's the plaintiff's attorney. Have you talked to a defense attorney yet? Okay, so what I'm going to do is, again, ask you to go into the hallway once this is done and speak to a defense counsel. Attorney Rude, if you all can come up with a conditional dismissal, with the agency attorneys today, then that's fine. But that would be, how are you all? And I'm speaking to the agency today. How do you all want to proceed with this?
Your Honor, typically with all first hearings, we ask them to go over if we can resolve the case today. It's highly unlikely we try to, but certainly we could at least discuss it in
Okay.
here. Next, Baker, Michigan Legal Services.
Okay, so for now, we're going to set this for an adjourn date of June 28th, 2023 at 9:30 a.m. You'll come back to court on that day. You'll come in person. It'll be back before me in this courtroom, 433. Okay, let me see what else. Plaintiff's counsel, please make sure you file everything that you need to substantiate your claim. I haven't looked through the file completely, but just on a cursory review, I see that there's a lease agreement in here, but I need the deeds for complaints to recover possession of property, okay? So these matters ending in 958 and 959 are adjourned to June 28th at 9:30 a.m. That concludes these matters. Ladies, please just wait in the hallway for your paperwork. You are going to receive a notice to appear. They'll bring it out to you, and then please go to room 417 so that you can speak with a defense attorney, and then you all can negotiate the terms of a conditional dismissal. Okay? All right, that concludes this matter. All right, so I did not receive a response on the other matters that I called for. Matter ending in 955 Edwina Sykes or any occupant of 14414 Corbett D107. Are you here? Okay, there's no one who responded to that, Attorney Rupert. I don't have a proof of service. Was this defendant served?
Personal service on June 6th, Your Honor.
Personal on June 6th. Okay, so this matter is going to be adjourned to June 28th, 2023 at 9:30 a.m. based on your representation that the defendant was served. If the defendant does come into this courtroom today, they'll be afforded an opportunity to speak to counsel as well as provided with the adjourn date. Please make sure you provide the proof of service to the court before the next court date. That concludes the matter ending in 955. For matter ending in 956, Lachey Smith or any occupant of 9441 Queen C106, did you make it into the courtroom? All right, the court notes a continued lack of response from this defendant. Attorney Root, was this defendant served?
Posted on 6/6, Your Honor.
Thank you. Based on plaintiff's counsel's representation that the defendant was served, the court is adjourning this matter to June 28th at 9:30 a.m. That'll be in person in my courtroom 433. Attorney Root, please make sure you file the proof of service.
Yes.
Thank you. That concludes the matter ending in 956. For matter ending in 957, Sherry Anderson, or any occupant of 14414 Corbett D106, are you here? The court notes a continued lack of response from this defendant. Attorney Rude, was this defendant served?
Yes, Your Honor, posted on June 6th.
Thank you. Again, I don't have the proof of service in the file. Please make sure you file it before the next court date. This matter is adjourned to June 28th, 2023 at 9:30 a.m. That'll be in person in courtroom 433. If the defendant comes into this courtroom today, they will be provided an opportunity to speak with counsel and given the adjourned court date. That concludes the matter ending in 957. Okay. All right, so I'm going to go on to the next group of files for Attorney Rude. Okay. Okay, again, please listen out for your name, case number, and or address, and try to step up in the order in which your case is called. Now calling case number 23348-960, Alta Chalmers LLC versus Lisa Fisher and all occupants of 9411 Queen C202 in the city of Detroit. Also calling case number 23348-961, Alta Chalmers LLC versus Mariska Penn-Darvis and all occupants of 9441 Queen C111 in the city of Detroit. Also calling case number 23348-963, Alter Mile Group versus Bernard Ingram and all occupants of 4102 Somerset in the city of Detroit. Also calling case number 23348-964, Alter Mile Group versus Tamala Gibson and all occupants of 6184 Guilford in the city of Detroit. Also calling case number 23348-965, Alter Mile Group LLC versus Janae Johnson and all occupants of 18611 Maross in the city of Detroit. Also calling case number 23348-966, Alter Mile Group versus Dominic Melton and all occupants of 8810 Farmbrook in the city of Detroit. And finally calling case number 23348-970, Adajar Investments versus Mercedes Smith and all occupants of 19332 Westphalia in the city of Detroit. These matters are before the court on complaints to recover possession of property. Ma'am, standing with the glasses, what is your name?
My name is.
Okay, good morning to you, Ms. Fisher. You are the defendant, thank you, on matter ending in 960. You're here on a complaint to recover possession of property. Ma'am in the yellow shirt, what is your name? Okay, good morning to you, Ms. Pendarvis. You are the defendant on matter ending in 961, and you are also here on a complaint to recover possession of property. And ma'am, with the braids, what is your name?
Mercedes Smith.
Good morning to you, Ms. Smith.
Good morning.
You are the defendant on matter ending in 970, and you are before the court on a complaint to recover possession of property. Okay, all of these matters are scheduled for a first hearing today. And pursuant to our Michigan Supreme Court's Administrative Order 2020-17, all first hearings have to be adjourned. So these matters are going to be adjourned to another court date. Your next court date is going to be June 28th at 9:30 a.m. So you'll come back down to court on that day, June 28th at 9:30 a.m. You'll come back to my courtroom. It'll be in person. Okay. Again, Attorney Rude, please make sure you file your proofs of service because I don't have them in this file, these files either. And also all substantiating documents, including the deed, the property management agreement if there's one, a lease agreement if there's one in existence. Ma'am, what did you want to say?
Hi, thank you. I didn't receive a post-dated notice on the 5th. That's Orchard. The papers themselves, when you get the papers now, it's Orchard. There's a lot of fraudulent, illegal activity going on at Orchard Charmers LLC. And all of the parties that are responsible for the upkeep of this building are aware of what's going on and what's not going on.
Okay, I'm gonna stop you right there just for a moment. This is the first hearing, so I don't adjudicate anything today. The reason we have a first hearing, and the reason that the first hearings are adjourned is to give you an opportunity to speak to an attorney, okay? I was going to advise you that you do have the right to be represented by an attorney. You can either hire your own attorney or you can speak to an attorney from a legal services agency. We have defense attorneys who are here today to speak to you, the defendant tenants, to provide legal advice, okay? So whatever issues that you're having, you need to communicate that to the agency attorneys. So when this hearing is done, you're going to go in the hallway to wait to receive your paperwork. Once you get your paperwork, please go to room 417. They'll register you to speak to an attorney. Are you all actually speaking to tenants today?
Your Honor, we are doing intakes, and when possible, we are trying to talk to tenants. However, we do reserve most talking to second ones.
Okay, can you just put your appearance on for me? Thank you. All right, so just for the information that you are trying to tell me, please make sure you tell that to the attorney so they can know how to proceed, okay? All right, so I think that is it. I've given you your dates. Please make sure you come back on the 28th in person. If you don't come back to court, the plaintiff will seek a default unless you all have worked something out. So please make sure you come back to court. Make sure you speak to an attorney. And Attorney Rude, please make sure you file your documents. Okay.
My appearance on this, Your Honor, Brian Rude, B7709.
So sorry about that, Attorney Rude. Okay, thank you. So that concludes the matter ending in 970, the matter ending in 961, and the matter ending in 960. You all can go into the hallway to wait on your paperwork and then go to room 417. Thank you. All right, for the remaining matters, matter ending in 963, Bernard Ingram or any occupant of 4102 Somerset, did you make it into this courtroom? The court notes that the defendant has failed to respond. Attorney Rude, you want to just, did you put your appearance on for all the other matters too as well, right?
Yes.
Okay. Okay, so Bernard Ingram or any occupant of 4102 Somerset have failed to respond. Were these defendants served?
Posted on June 5th, Your Honor.
Thank you. Based on plaintiff's counsel's representation that the defendants were served, this matter is adjourned to June 28, 2023 at 9:30 a.m. It will be in person back in my courtroom, courtroom 433. If the defendant comes into this courtroom today, he or she will be afforded an opportunity to speak to counsel and provided with the adjourned date. That concludes the matter ending in 963. For matter ending in 964, Tamla Gibson or any occupant of 6184 Guilford, are you present? This is a complaint to recover possession of property. The court notes that the defendant has not responded. Attorney Rude, was this defendant served?
Posted on June 6th.
June 6th?
Yes.
Thank you. Based on your representation, the court is going to adjourn this matter to June 28th, 2023 at 9:30 a.m. That'll be in person in courtroom 433. Defendant will receive notice via mail, and if they come into this courtroom today, they will be provided with the adjourn date and provided an opportunity to speak to counsel. That concludes the matter ending in 964. For matter ending in 965, Janae Johnson or any occupant of 18611 Maross, are you here? This is a complaint to recover possession of property. The court notes that the defendant has failed to respond. Attorney Rude, was this defendant served?
Posted on June 5th.
Thank you. Based on Attorney Rude's representation that the defendant was served, the court is adjourning this matter to June 28th, 2023 at 9:30 a.m. That'll be in person in courtroom 433. Attorney Rude, please file all of your substantiating documents on or before the next court date. If the defendant does come into this courtroom today, he or she will be provided with an opportunity to speak with an attorney as well as provided the adjourn date, and notice will be sent. That concludes that matter. For matter ending in 966, Dominic Melton or any occupant of 8810 Farmbrook, are you here? The court notes that the defendant has failed to respond in this complaint to recover possession of property. Attorney Rude, was this defendant served?
Yes, Your Honor, posted on June 5th.
Thank you. Based on Attorney Rude's representation that the defendant was served, this matter is adjourned to June 28th, 2023 at 9:30 a.m. That'll be in person in courtroom 433. The defendant will be served with notice, and if the defendant comes into this courtroom today, they'll be provided with an opportunity to speak to an attorney as well as provided the adjourn date. That concludes this matter. Thank you, Attorney Rude. Have a good day.
I'll be back at 9:30.
Okay, well, see you in a few minutes. Okay. Is Attorney Horker standing there for Attorney Scott? Oh, okay. Oh, okay. All right, so okay, I'm about to call the matters. Plaintiff is being represented by Attorney Cohen. Let's see, those 5 cases. I'm going to call them all at one time. If you hear your name, address, or case number, please step up in the order in which I call the cases. Now calling case number 2334900, Orleans PO LLC versus Kevin James and all occupants of 1505 East Larned, number 2 in the city of Detroit. Also calling case number 2334900, Orleans PO LLC versus Green Ingram and all other occupants of 1535 East Larned, number 6 in the city of Detroit. Also calling case number 2334900, Virginia Park Acquisition LLC, thank you, versus Ronald Gervin and all other occupants of 2021 Blaine Street, number 218 in the city of Detroit. Also calling case number 2334900, Virginia Park Acquisition LLC versus Carmela Threat and all other occupants of 2021 Blaine Street, number 311 in the city of Detroit. And finally calling case number 2334900, Orleans PO LLC versus Stacy Barnes and all other occupants of 1523 Larned, number 6 in the city of Detroit. These matters are before the court on complaints for non-payment of rent. Can I have plaintiff's counsel place your appearance on the record?
Morning, Marilyn Cohen, P1939, here on behalf of plaintiff.
Thank you. Good morning, Attorney Cohen. Ma'am, what is your name?
Renee Booth.
Okay, good morning to you, Ms. Ingram. You are the defendant on matter ending in 001, which is a complaint for non-payment of rent. This is the first hearing held in your matter pursuant to Michigan Supreme Court Administrative Order 2020-17. All first hearings shall be adjourned. Therefore, this matter is going to be adjourned. The next court date for your case is going to be June 28th, 2023 at 9:30 in the morning. On that day, you'll come back to court in person in my courtroom, 433. Let's see, Attorney Cohen, I don't have proofs of service for any of your files. Please make sure that they are filed with the court on or before the next court date. Also, please make sure that all substantiating documentation is filed before the next court date.
I have right here. It's in your file.
Well, are you talking about just for matter ending in 001 right
I
now?
have these for all of them right here in my file.
If you filed them already, then like I see a covenant deed for this one, just I'm flipping through.
Oh,
If you've already filed them, then that's great. I haven't looked through each file to see what's in here or what's not. But I do know that the proofs of service aren't in here, so
I don't know why. I mean, is it showing the register back?
I haven't pulled it up.
Craig Gregory, he was supposed to be telling me. Know that I have proof of service on them.
Okay. Let me look at the register of actions. Okay, for instance, for this matter, which is matter ending in 001, I do see where a proof of service was filed, so it hasn't made it to the court. So again, if you have not filed the proofs of service, please make sure you do so on or before the next court date. All right, ma'am, Ms. Ingram, you as the defendant do have the right to be represented by an attorney. You can either hire your own attorney or you can speak to an attorney from a local legal services agency. We have defense attorneys here from a legal service agency who are here to provide you with legal advice. It's free of charge. And, you know, they'll speak to you and provide you advice for the day with the possibility of them taking on your case to represent you throughout the close of these proceedings. At the end of today's hearing, I'm going to ask you to go into the hallway, wait on your paperwork. Our court clerk is going to send out a notice to appear for the next court date, which is June 28th. Once you get that paperwork, please go to room 417 to register to speak to an attorney. Okay? All right, that concludes the matter ending in 001. Please make sure you come back on the 28th, ma'am. Thank you, Madam Clerk. For matter ending in 000, Kevin James or any occupant of 1505 East Larned number 2, are you here? All right, the court notes that Kevin James has failed to respond. There's no proof of service in the file. Attorney Cohen, when was this defendant served, if at all?
Well, it was personal service, Your Honor. Like I said, Mr. Gregory filed it with the court, and I think you'll see it on the register of actions, but he's a few minutes out in terms of.
Okay, so I'm going to, do you know when it was served personally?
Unfortunately, I don't have the date it was personally served. I have a representation that it was.
Okay, the register of action says posted.
Oh, okay.
So, I mean, that's why I like to see the proofs of service. That's fine. I know that there's one on its way. So this matter is adjourned to June 28th, 2023 at 9:30 a.m. Attorney Cohen, please connect with your officer to find out when he filed those proofs of service. And
well, you do see it on the register of action.
I do, but I'd like to have them in my file. So if you can get, if you can get a copy, just can you bring it back next time just in case it doesn't make it? Okay, thank you. That concludes the matter ending in 000. matter ending in 002, Ronald Gervin, are you present? Ronald Gervin or any occupant of 2021 Blaine Street, number 218 in the city of Detroit. Okay, the court notes that it's received no response from this defendant. This is a complaint for non-payment of rent. There's no proof of service in this file. Let me pull up the register of actions because I presume you don't know when or how the defendant was served, Attorney Cohen.
Yes, I apologize.
Okay, so this one says posted. So I'm going to adjourn this matter to June 28th, 2023 at 9:30 a.m. And if the defendant comes into this courtroom today, he will be provided with an opportunity to speak to an attorney and provided with the adjourn date. And hopefully the proof of service makes it to my file before the next court date. That concludes the matter ending in 002. For matter ending in 003, Carmela Threats, did you make it into this court session today? The court received no response from this defendant. Let me pull up the register of actions. Okay, there is an entry on the register of actions. It looks like a proof of service was filed. Do you know when the defendant was served, Attorney Cohen?
I apologize.
Okay. So based on the register of actions reflection of a proof of service, I'm going to adjourn this matter to June 28th, 2023 at 9:30 a.m. That'll be in person in my courtroom. If the defendant does come into this courtroom today, he will be provided, or she will be provided with an opportunity to speak to counsel and provided with the adjourn date, as well as the court will serve notice upon the defendant at the address of record. Hopefully, I receive the proof of service soon. That concludes the matter ending in 003. For matter ending in 004, Stacy Burns, are you present?
Moving for dismissal on that one, Your Honor.
Thank you. What is the reason?
I believe the defendant paid.
Okay. So the court notes that the defendant failed to respond. The court also notes plaintiff's motion to dismiss based on payment. This matter is dismissed without prejudice. Attorney Cohen, do you have a dismissal order?
It was sent to the court, Your Honor, but
Okay.
next time I come, I'll just bring it.
Okay, that's fine. Let me see if, I don't know when you filed it. I'll see if it's in
I'm
the
sure it
register.
was
of
probably
actions.
by like Friday, probably doesn't be it anywhere.
Yes, it has, the register of actions doesn't even reflect this. So I'll just note plaintiff is to submit the order and I will sign it once I receive it. That concludes the matter ending in 004. Thank you. Have a great day. All right, we have a few more to handle off the 8:30 docket. Is Attorney Cox here? All right. Attorney Jarbo. Now calling case number 23349-018. High Tech Properties LLC, successor in interest to BGI MMC LLC versus all occupants of 1A801 Eureka Street in the city of Detroit. May I have, I'm sorry, this matter is scheduled for a first hearing on a complaint to recover possession of property. Can I have the plaintiff's counsel place your appearance on the record?
Good morning, Your Honor. Joe Horka, P75969. I'm appearing for Sam Jarbo for the plaintiff.
Thank you. Good morning to you, Attorney Horka. Is there anyone who lives at 18801 Eureka Street? If so, please come forward now.
And I don't expect anybody, Attorney Jarbo's office didn't get the pleadings back in time for service, so I'm requesting adjournment.
Okay, thank you, Attorney Horka. This matter will be adjourned to July 10th, 2023 at 8:45 a.m.
I'll look for Attorney Wilburn. She's standing in for Mr. Cox. I'm here for Mark Landau later.
Okay, thank you. That concludes the matter ending in 018.
We have a case note. Check the.
Nobody checked in?
No.
Now calling case number 23348-911 Kenyatta Lee versus Stephanie Atkins of 10333 Balfour Road in the city of Detroit. This matter is scheduled for a first hearing on a complaint for non-payment of rent. Is Kenyatta Lee the plaintiff present? What about the defendant, Stephanie Atkins? Okay, the court notes that neither the plaintiff nor the defendant have responded in this matter. Rather than dismiss this matter for plaintiff's failure to appear, I'm going to adjourn it pursuant to the Michigan Supreme Court Administrative Order 2020-17. Noting that the Register of Actions does not reflect service in this matter. I'm adjourning this matter to July 10th, 2023 at 8:45 a.m. If the plaintiff fails to appear at the next hearing, this matter will be dismissed. That concludes this matter.
My name is Attorney Cox.
Okay. Has any tenant checked in on any of Attorney Cox's? Okay, so to the tenants who are here for our 8:30 docket where the plaintiff is being represented by Attorney Cox, I have 3 of those matters. That would be Michelle Adams, Rhonda Gwynn, and Kinshia Spillman. We are waiting on the plaintiff's counsel to come into the courtroom. As soon as the plaintiff's attorney comes in, we will call those cases. So I'm going to move on to the 9:30 docket now. I'm sorry. I'm moving on to the 8:35 docket. Once.
May I address the court? I've been here since 8:20. I'm on the 8:30 call.
What is your case?
It is United States Trust Associates versus James Cornet. It's case number 23-346-466.
I just said I was calling the 8:35 docket next. So you can come up to the podium. Now calling case number 23346-466 U.S. Bank Trust National Association as trustee of the Cabana Series 5 Trust versus unknown heirs and legatees of James O. Cornet Jr. and all other occupants of 15469 Cedar Grove Street in the city of Detroit. This matter is, what is this scheduled for? This matter is scheduled for pre-trial on a complaint to recover possession of property. May I have your appearance, please?
Good morning, Your Honor. My name is Michael Conway, C-O-N-W-A-Y. My bar number is P12165.
Thank you. Good morning, Attorney Conway, and you are for the plaintiff, correct?
That's right, Your Honor. I'm filling in for Franco Raleigh, who's the attorney of record.
Okay, thank you. So, is there any unknown heir or legatee of James O. Cornet Jr. or any occupants of 15469 Cedar Grove Street in the city of Detroit? If you are present, please step up now if you are present. Okay, thank you. The court notes that it has received no response or the defendant has failed to appear. Attorney Conway, you have the floor.
Your Honor, we're seeking obviously a notice of session on this matter. Is this going to be adjourned over to?
Well, I don't know because I'm trying to figure out why it was scheduled for 8:35, but I see. So the first time we were in court in April, there was no service, and then it was adjourned to May 25th. Attorney Bornkamp appeared on May 25th. And then he told me that there was personal service on May 22nd. And so it was scheduled for a pre-trial today. It says 9:30. I don't know why your matter was scheduled for 8:35. So this is a pre-trial, correct?
That's what my understanding is, Your Honor.
All right, I do have a proof of service in the file. It does indicate the service was effectuated by posting at 15469 Cedar Grove Street in Detroit on May 22nd at 3:01 p.m. Is there what is the basis of your complaint for
Well, Your Honor,
possession?
our complaint is that this property was sold by sheriff's sale on July 7th, 2022. The period of redemption has expired and we're seeking possession.
When did the period of exemption expire?
6 months from July 7th of 2022, so that'd be 6 months from that date.
Okay. So that would be January 2020, January 7th, 2023, on or about. All right, so there is a summons in the file, a complaint to recover possession of property. There is a sheriff's deed on mortgage sale in the file, which was executed on July 7th, 2022, indicating that, there was a sheriff's sale of the subject property, commonly known as 15469 Cedar Grove Street in the city of Detroit. This deed was recorded by the Wayne County Register of Deeds on September 8th, 2022. An affidavit of publication, and evidence of sale, and an affidavit regarding military status, as well as the affidavit of purchaser at foreclosure sale to be recorded with to be recorded with sheriff's deed. That was executed on September 6, 2022. I already indicated the terms that are noted on the proof of service. Is there any occupant of 15469 Cedar Grove Street here? If so, now's the time to step up. Okay, the court notes that the defendant has failed to appear. The defendant failed to appear at the last court hearing of May 25th, 2023. However, the court did issue notice.
Your Honor,
Yes,
you haven't seen the book, right? All right, Your Honor.
no problem, officer. Thank you. The court did issue a notice to appear for today's hearing on May 25th, 2023. The defendant having been properly served with notice of these proceedings and with notice of today's court hearing, the court is going to grant plaintiff's motion for default judgment. And let's see. The occupants of the home are to vacate by July 3rd, 2023. That is the judgment of the court. Attorney Conway, do you have a judgment to present today?
Your Honor, I do. I could furnish today.
Okay, no, just hand it to the bailiff and he'll give it to me. Thank you. That concludes this matter.
Thank you, Your Honor.
You're welcome.
Okay. Let's see.
No, I was looking at the calendar. Okay, we're moving to the 9:30 docket now. Is Attorney Alva present? Thank you. Now calling case number 23346-396. The Bank of New York Mellon as co-trustee for Mortgage Equity Conversion Asset Trust 2010-1 versus Mary Sims and all other occupants of 9171 Sorrento Street in the city of Detroit. This matter is scheduled for a pretrial on a complaint to recover possession of property. May I have appearances, please? Thank you. Good morning to you, Attorney Albu. Is Mary Sims or any occupant of 9171 Sorrento Street present? If so, please step up now. The court notes that it's received no response from the defendant. Attorney Albu, you have the floor. Thank you. The court notes that there is a summons, a complaint, and a complaint to recover possession of property and a sheriff's deed on mortgage sale in the file, and it does reflect that a sheriff's sale occurred on September 1st, 2022 to the plaintiff. And the subject property is that commonly known as 9171 Sorrento in the city of Detroit. This was executed on September 1st, 2022 and recorded by the Wayne County Register of Deeds on September 14th, 2022. There's also an affidavit of publication and of sale and an affidavit of purchaser in the file, as well as an affidavit regarding military status, as well as a proof of service, which indicates that the defendant was served by posting on April 21st, 2023 at 5:13 p.m. at 9171 Sorrento in the city of Detroit. The court notes that the defendant has never appeared in this matter. And specifically, I'm speaking about the first hearing, which was held on May 25th, 2023. However, the defendant was provided with notice to appear for today's court hearing on May 25th, 2023. The defendant having failed to appear and having been properly served with notice of these proceedings and specifically of today's court date, the court is going to grant your motion for a default judgment of possession. Was there a named defendant here? Let's see. Okay, the defendant is to vacate by July 3rd, 2023. That is the judgment of the court. Do you have one to present? Okay, thank you. Thank you. Okay, I have signed the judgment that was presented. I did too. Okay, that concludes this matter. Thank you. Now calling case number 23346-400, Mortgage Assets Management LLC versus Odell Hayes and all other occupants of 12,000 Wayburn Street in the city of Detroit. This matter is scheduled for pretrial on the complaint to recover possession of property. May I have your appearance again? Thank you, Attorney Albu. Is Odell Hayes or any occupant of 12,000 Wayburn Street present? So please step up now. Court notes that it's received no response. Attorney Albu, you have the floor. Thank you. Attorney Albu, can I ask you, do you know that the named defendant is actually residing in the home still? And the reason I ask this is because I'm entering these default judgments against these named parties, but I don't know that they are even still in the home to have received notice. It says, well, this one says there's personal service, but it's personal service upon an occupant. So that's not really personal service. I mean, I don't know who the occupant was. So, I mean, what do you have to say with respect to the default judgment? I'm just asking because if this was a mortgage foreclosure, sometimes people leave and what is your position on that?
We named the prior mortgage, or we don't want to live there for sure. So I can speak into the judgment law.
Okay. It just, okay, so that's what I'll do. I'll do a default judgment against all occupants, and the occupants are to vacate by July 3rd, 2023. Yes, and with respect to your previous case number 233463996, I guess I have the same question. Do you know that the named defendant is still residing in that home?
No, we can have to do the judgment against the law.
Okay, so I'm going to change that one to all occupants as well. Thank you. That concludes these matters. If you have a judgment on the other, can you present it to the officer? Thank you. Has Attorney Cox's stand-in coming to this courtroom yet?
Yes, I'm here, Your Honor.
Okay, thank you. I'm going to call those 830 cases next. Just give me one moment.
Oh.
Thank you. Okay, I'm calling these cases off of the 830 docket. These cases are represented, well, the plaintiff is being represented by Attorney Cox. Please listen out for your case number, name, and/or address. There are 4 cases, so please try to step up in the order in which I call you. Now calling case number 233488885, Go To Guy Property Management LLC versus Michelle Adams and all occupants of 19320 Dale in the city of Detroit. Also calling case number 233488974, Woodbridge Estates Phase 4 versus Rhonda R. Gwynn and all other occupants of 1114 Marvin Gaye Drive in the city of Detroit. Also calling case number 23348-980, Logical PM versus Kinshia Lanika Spillman and all other occupants of 15348 Murray Hill Street in the city of Detroit. Also calling case number 23348-941, 532 Tidal Way LLC, the Jeffersonian versus Wrigley's Pharmacy and all other occupants of 9,000 East Jefferson Avenue in the city of Detroit. Yes, ma'am.
That matter we are going to be dismissing.
Okay, can you place your appearance on the record for all of the matters?
And matter ending in 941 by two Tidal Way Wrigley's Pharmacy, we will be dismissing. It will get that paperwork in the court.
What's the reason for the motion to dismiss?
Down to state law.
Okay, this is a complaint for non-payment of rent. The court notes that the defendant has failed to respond. This matter is dismissed without prejudice, and I will note that plaintiff will submit a dismissal order. That concludes this matter. That's matter ending in 941. Ma'am, what is your name? Michelle Adams. I'm sorry. Ms. Adams, you are the defendant on matter ending in 885. You are before the court on a complaint to recover possession of property. And this is the first hearing scheduled for your matter. Pursuant to Michigan Supreme Court Administrative Order 2020-17, all first hearings are to be adjourned. Therefore, this matter is going to be adjourned to June 28th, 2023 at 9:30 a.m. On that date, you'll come back to court. You'll come back to this court. It's in person, so you'll come to courtroom 433 in my courtroom. Let's see, Attorney Wilburn? I don't have the proofs of service for any of these matters. She's here, so it's not an issue with this one yet, but I do need you to submit the proof of service if you have it, and you have not done so already. Also, please make sure that if you haven't done so already, you submit the deed, the lease agreement if there's one applicable to the case, and a property management agreement if it is applicable. Ms. Adams, you have the right to be represented by an attorney if you so choose. You can either hire your own attorney or you can speak to an attorney from an agency. We have attorneys from a legal agency present here today to speak to you, to provide you with legal advice for the day with the potential of them taking on your case to represent you throughout the close of these proceedings. At the end of today's hearing, the court clerk is going to send paperwork out to you. So I'm going to ask you to step into the hallway. Once you receive your paperwork, the paperwork is just the notice to appear for the next court date, which is June 28th at 9:30. Once you get that, please go to room 417 to register to speak to an attorney, okay? All right, let's see. That concludes the matter ending in 885. Ms. Adams, you are free to go. Just please step outside and wait on your paperwork. For this one? Yes, can you just give it to the deputy? Thank you.
Other two matters, Your Honor, cases ending 974 and 980, we did not obtain service yet, so we need to adjourn.
Okay, thank you for that, Attorney Wilburn. So these matters ending in 974 and 980 will be adjourned to July 10th, 2023 at 8:45 a.m. to allow for service of the defendant. That concludes these matters. Thank you, Attorney Wilburn.
Thank you, Judge.
Have a good day. 8:45.
This is her 9:30.
Okay.
Attorney Wilburn.
I'm going to call your 9:30 case next, ma'am. Just give me a second so I can make my notes.
You said 8:45 for that?
For matter ending in 980 and 974. Yes.
8:45.
Yes. Okay, both of these are for her? All right, thank you. Now calling case number 23347-951, Pananima LLC versus Felicia Register and all other occupants of 19242 Maross in the city of Detroit. This matter is scheduled for pretrial on a complaint to recover possession of property. May I have plaintiff's counsel place your appearance on the record?
Good morning again, Your Honor. Jen Wilburn, P 83143.
Thank you. And ma'am, what is your name?
My name is Terry Morrow. My mother deceased, she's Felicia Register.
Thank you. Good morning to you, Miss Morrow. Let's see. Can I have you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You can lower your hand. Okay, this is a complaint to recover possession of property. Attorney Wilburn, where do we stand?
Your Honor, this is a termination of tenancy with this present expired.
Okay, Ms. Morrow, what did you have to say in response?
I don't have a copy of it. So I was hoping to get a copy of the lease. And then I needed a little bit of time to get my brother out of the house because he's fully disabled. And I brought documentation to show that.
Okay, so I will definitely give you an opportunity to speak so that you can see the lease. I have, let's see what I have in the file. I have the summons, the complaint to recover possession of property, the notice to quit to recover possession of property that was issued to Felicia Register and all occupants. It says and or all other occupants at 19242 Marossa in the city of Detroit. This went out on March 7, 2023 and demanded that the occupants vacate the premises on or by April 7, 2023. It was delivered via first class mail. I do have a copy of a lease agreement in the file. And it looks like it was executed by Ms. Register and the plaintiff on November 23rd, 2021. I don't know if there's been an addendum since then. But what I'm going to do is pass on this matter to allow you to speak to the defendant, Attorney Wilburn. Did you have an opportunity, Ms. Morrow, to speak to legal counsel previously?
They didn't really want to talk to me because I wasn't the defendant.
Oh, you don't live at the house, do you?
And I'm not able to fully take care of my brother who's disabled. So I've been trying to get him help, but it's really slow in Wayne County to get him help.
Okay, what is the extent of what? Okay, can you all talk? I'm going to pass on this matter, okay? All right.
Do you want to take care of the other?
I'm going to call the other one first and then I'll pass. Now calling case number 23347-993, True Properties LP versus any and all other occupants of 10030 Manor in the city of Detroit. This matter is scheduled for pretrial on a complaint to recover possession of property. May I have your appearance first, plaintiff's counsel?
Jen Wilburn, P 83143.
And good morning, Your Honor. Tom Barashak, P 83642, on behalf of the occupant Arnisha Taylor. Ms. Taylor, unfortunately, isn't going to be able to make it today, but she's authorized me to maybe work on a settlement. We haven't had a chance, Your Honor. Could we set this aside very briefly so I'll trade? So Wilburn and I can discuss it.
Sure, I will pass on both of Attorney Wilburn's matters. Thank you, Attorney Barashak.
Thank you.
Is Attorney Hughes here?
Yes. So we have one.
Oh, okay. Now calling case number 23347-959, Charlotte Detroit LLC versus Amber C. Dunson and all occupants of 10210 Second Avenue, number 103 in the city of Detroit. This matter is scheduled for a pretrial on a complaint for non-payment of rents. May I have appearances, please?
Morning, Judge Paul Hughes, P31986, appearing on behalf of the plaintiff. This is a non-payment possession action second.
Thank you, Attorney Hughes. Give me 1 second. I'm going into my register of actions, but maybe you can answer the question before I pull up the case. When we were last in court on May 25th, my notes say at first you were unable to articulate service, so the matter was initially going to be scheduled for another first hearing, but then you said he was served by posting.
Yes.
On May 14th.
Yes.
Do you have a proof of service? I don't have one in the file. Okay, can you give it to the officer, please?
Officer.
It doesn't.
Thank you, Madam Clerk. Okay, so, all right, so we have our proof of service. You have the floor, Attorney Hughes.
Thank you, Your Honor. We would ask for a default judgment for this non-payment possession action. The amount of rent is $7,085.71, court cost of $162, for a total amount due $7,347.71. We ask that judgment be entered to confirm payment within 10 days or to issue.
Okay,
I have prepared the judgment.
do you have the lease agreement or a deed or something?
I have a lease agreement, yes.
All right, do you have one for the file? I don't have
Yes.
one in the file.
Yes.
Thank you. All right, so the court notes that within its file is a summons and a complaint for non-payment of rent, along with the demand for possession for non-payment of rent that was issued to Amber Dunson and all occupants of 10210 Second Avenue, apartment 103 in the city of Detroit on April 6, 2023 by first-class mail addressed to the person in possession. I also have a lease agreement, which I've just been presented with. It is between Timeless Properties Detroit, the landlord, and Amber C. Dunson. It is for the property located at 10210 Second Avenue, 103 in the city of Detroit. And it runs from December 5th, 2022 to December 4th, 2023. It looks like it was executed by electronic signature. Attorney Hughes, do you have a property management agreement that connects your client to this property?
I have a deed, Your Honor. The property was sold since that particular lease was signed. The deed is electronic and I can email it to you. I just received it this morning.
Okay, Attorney Hughes, I'm going to adjourn the matter because we're in person now and, you know, we don't like doing the email thing. So, let's see.
Show the court the deed on my phone. It's right here.
I know, but I can't hole punch your phone and put it in the file,
I
so.
can submit a copy to the court, so, you know, by filing today.
Are you going back to your office and coming back?
Well, I can do that too. Yes.
Okay, well, I can pass on the matter. But if I don't have the paper copy of the deed, I'm going to adjourn it, okay?
All right, so I'll go to my office and come back and you'll call the case again, or you want to?
If you get back within a reasonable amount of time, yes,
Okay.
before lunch. Can you get
Yeah.
back before lunch?
Of course.
Okay, I'll recall it then.
Well, you want to just enter the default
No,
subject to that?
I want to see it. Thank you. Is that your only case in here, Attorney Hughes? All right, I'll see you in a minute.
See you.
Anything else? Okay.
That's the term.
Ready? Okay. All right, I am about to call matters represented by Attorney Paylett. If the plaintiff is being represented, if you're on a case where the plaintiff is being represented by Attorney Paylett, please listen out for your name, address, and case number. Now calling case number 23347-964, The Pavilion versus David Butter and all other occupants of 1 Lafayette Plaisance, number 415 in the city of Detroit. This matter is scheduled for pretrial on a complaint for non-payment of rent. May I have your appearance, sir?
Michael O'Malley on behalf of Pinellas Law for the plaintiff, Your Honor. 59108.
Thank you. Good morning to you, Attorney O'Malley.
Morning.
All right. David Butter, are you present? David Butter, ouch, or any occupant of 1 Lafayette Plaisance, number 415. All right, the court notes that it's received no response. Attorney O'Malley, you have the floor.
Your Honor, it's my understanding this was served via posting on May 22nd.
Okay, thank you for that, Attorney O'Malley. This is a complaint for non-payment of rent. How much is outstanding?
Outstanding $7,269, $161.50 in court costs for a total of $7,430.50. Last for possession over judgment with the writ date to issue after June 22 of this year.
Okay. So the file does contain a summons, a complaint for non-payment of rent. Okay. In addition to a demand for possession for non-payment of rent that was issued to David Butter at 1 Lafayette Plaisance, apartment 415 in the city of Detroit on April 11, 2023. Also, the court file does contain an apartment lease contract. It was executed between David Butter and Pavilion Apartments Limited Partnership. This took place on February 2nd, 2023. It was executed by, David Butter and the owner's representative. And it was for the property located at 1 Lafayette Plaisance, apartment 415 in the city of Detroit. Additionally, there is a proof of service in the file, which indicates that the defendant was served by posting on May 22nd, 2023 at 12:32 p.m. There's also a quitclaim deed in the file conveying the property to Pavilion Apartments Limited Partnership. And that conveyance took place on December 5th, 2008. David Butters, are you here? If so, now's the time to step up. The court notes that the defendant has failed to respond. The defendant did not appear at the court's first hearing on this matter, which was held on May 25th, 2023. However, notice was issued by the court to the defendant to appear at today's court hearing. That notice went out on May 25th, 2023. The defendant having failed to appear, let's see, what time was this matter scheduled for?
9:30.
9:30. Okay, I'll grant the default now. It's 10:15. The defendant having failed to appear, this matter having been scheduled for 9:30, it now being 10:16 a.m. and the defendant having been served with notice of these proceedings and of notice of today's court hearings, the court is going to issue a default judgment of possession. The defendant is to pay $7,430.50 or vacate the premises by June 30th, 2023.
Give me 1 second, Your Honor, and I will modify the.
Okay. That is the judgment of the court. Plaintiff, I think you said you have a judgment. Once you present it, I will sign it.
I do, Your Honor, just 1 second to change.
Okay, no problem. That concludes this matter.
Yes.
Okay, they're right here. I will call them next. Thank you. These are all for the same one?
I need 2 more, right?
Yeah. I think you got 2 more.
So my question is, why, do I need to sign all of these? He gave me 4 judgments.
I can.
Okay. All right.
Sorry, they were in reverse order. Your version was probably the bottom.
Oh, okay. So it was supposed to be one of those that went all the way through.
I wanted to show true copy of the rest.
Oh, it didn't go through. I can reverse it if that is possible.
I don't have a true copy.
Okay. All right, let me see here. This one. You know what, whatever, I'll just sign them all.
Or just one that you're on?
No, it's fine. I guess they were, I don't know what happened. It's cool. I'll sign them all.
She represents this one.
I'll find out.
This one back here.
No, I want this one to talk to me.
I'm gonna go get my stamp.
Okay.
Our court is in recess for about 5 minutes. I'll be right back. Okay, thank you. I just had to pass so I could go get some stamps for you. To make things move a little faster.
I worked out with your clerk. She'll just make copies.
Okay, all right. Okay. Now calling case number 23347-968. The Pavilion. Go ahead. Oh, versus Michael Foster and all occupants of 1 Lafayette Place, apartment 1404 in the city of Detroit. This matter is scheduled for pretrial on the complaint for non-payment of rent. May I have your appearance, counsel?
Michael O'Malley, we have the town of Philadelphia plaintiff for ours.
Thank you. Sorry, I ran up the stairs. All right, oh, sir, can I state your name, please?
My name is Jarrell Butler. I'm not.
What's your first name?
Jarrell.
Jarrell?
R-R-E-L-L.
Jerrell?
R-R-E-L-L.
Okay. Butler? All right, thank you, Mr. Butler. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can lower your hand. All right, Mr. Butler, there was a Michael Foster who appeared last time. Do you know that person?
Yes.
Okay. All right. So, Attorney O'Malley, you have the floor.
Your Honor, this is a outstanding rent case, possession only, outstanding rent of $3,785.50, $161.50 in costs, seeking a total of $3,947.
All right, Mr. Butler, what do you have to say in response?
Mike and I, that's my stepbrother. We stay together now. We both have some tax issues where my account was frozen. So the IRS has sent out checks for us both. The checks aren't been approved. That's it.
So let me stop you. You said you've already paid in full, or you will be able to pay in full?
Yeah, to pay in full within like maybe, well, the email says 10 to 12 days. So we're just waiting on the check.
Okay. So Attorney O'Malley, do you object to an all occupant judgment?
I do not object to an all occupant judgment, Your Honor, that's fine.
Okay.
As for that amount, and of course, protocol is going to be June 30th. That should leave these gentlemen enough time for the check to come in full.
All right. Today's the 12th, sir. So when did you receive that email?
The email, I believe, was.
Okay, so the check should be in the mail at some point, right? It should be on its way.
It's in the mail now. So I have money in my account as well. The IRS froze the account, and it's scheduled to be unfrozen on the 1st of July. So the check comes, I'll pay it in full then, and the account, once the account is frozen, unfrozen on the 1st, I'll pay it full then. So either way.
Okay, so this is what I'm going to do. I'm going to issue an all occupant judgment. So that means that Mr. Foster's name will be dismissed because I don't think you were named. And I'm going to give you all until June 30th. Okay, so you are to either pay the amount or vacate by June 30th. The amount is $3,947. Pay $3,947.00, or vacate the premises by June 30th. Now, I know you said July 1st. June 30th is a Friday. July 1st is a Saturday. So even though this judgment is going to say June 30th, I think you'll have some time. Attorney O'Malley, would you agree?
If the court's closed, yeah.
The courts will be closed on, obviously,
On
Saturday and Sunday. And if the money hits on the 1st.
I mean, it's gonna be a check. I have it right here, the email. So see this amount. So I'm gonna have to deposit this check as well.
Okay.
So it's gonna take time to clear. But I do have every intention on covering the full dollars.
That comes from the federal government, sir?
This is from the tax government sent the check out and they sent it back.
Okay, so this is what I don't want to happen. I don't want a writ to be requested and then I schedule it for hearing or I sign a writ and then, he files a motion to stay. Do you have any objection to going until like July 6th, Attorney O'Malley?
I don't have the authority to agree to that, Your Honor, but let's put it this way, if you tell me that's what it is, then I'll agree with whatever the court tells me to do.
Okay, so, but you don't object to the all occupants, right?
I'm not saying the word object right now.
All right, so, so the judgment is going to be as to all occupants. Michael Foster will be dismissed. You all are to pay $3,947 or vacate by July 7th. So that gives you plenty of time for the money to hit, okay? Okay, so if you do not pay the $3,947 or move out by July 7th, the plaintiff is going to come to court and ask that it issue an eviction writ. Once I sign off on the eviction writ, that's what gives the plaintiff the authority to come out to the property with a bailiff and a dumpster to set your belongings into the street. To avoid that, please make sure you have either paid that amount or vacated by July 7th, 2023, okay? All right, that is the judgment of the court. I believe plaintiff is submitting the judgment now, and I will sign off on it right now.
Thank you, Your Honor. Yes, just for the record, have modified the proposed judgment to reflect the decision of the court.
Thank you. And I am signing it now.
Thank you.
Thank you. That concludes this matter. Now, thank you, sir. Just have a seat and wait on your paperwork. Now calling case number 23347-969, the Pavilion versus Odette Georges and all other occupants of 1 Lafayette Plaisance, number 0908 in the city of Detroit. This matter is scheduled for pretrial on a complaint for not payment of rent. Can I have your appearance, Counsel?
Yes, Your Honor. Michael O'Malley on behalf of Pallet Snore for the plaintiff, and we would move for a dismissal and to inform that the tenant is paid in full.
Thank you, counsel. Is the defendant here? Odette Georges, are you here? Or any occupant of 1 Lafayette Plaisance, number 908? Okay, the court notes that the defendant has failed to respond or failed to appear. However, the court also notes plaintiff's motion to dismiss based on the fact that the defendant has paid in full. This matter is dismissed without prejudice. Do you have a dismissal order to submit today?
I do not, Your Honor, but I'm sure the office has submitted one.
Okay, I'll note that plaintiff is to submit the order. I will sign it once I receive it. That concludes the matter ending in 969. Thank you, Attorney O'Malley.
Thank you, Your Honor.
You're welcome. Please, and come back already, Attorney. Okay, all right, I have this one in it. Wait, is this the recall?
Yes, Mr. Hugh.
All right.
Paperwork is
Okay, thank you. Let me recall that one. Recalling case number 23347-959, Charlotte Detroit LLC versus Amber C. Dunson and all occupants of 102 102nd Avenue in the city of Detroit. This is a recall of a pretrial on a complaint for non-payment of rent. May I have your appearance, Attorney Hughes?
Paul Hughes, 31986, appearing on behalf of the plaintiff, the court has requested the copy of the file submitted as a judgment that was previously put on record.
Thank you. Thank you, Attorney Hughes. I did already place on the record the proofs about what's contained in the file with respect to the lease. The court is in receipt of a warranty deed conveying the property commonly known as 10210 Second Avenue in the city of Detroit to the plaintiff, the Charlotte Detroit LLC. And that conveyance did take place on October 12th, 2018, and was recorded by the Wayne County Register of Deeds on October 22nd, 2018. I don't know if I put this on the record before, but just in case I didn't, there is a proof of service in the file, which indicates that the defendant was served by posting at 10210 Second Avenue, number 103 in the city of Detroit on May 14th, at 10:28. I think I did put that on the record. The defendant having been properly served with notice of these proceedings, the court is going to issue a default judgment of possession. The defendant is to pay $7,247.71 or vacate by June 30th, 2023. That is the judgment of the court. It looks like you've already presented a judgment, Attorney Heath. I will sign it now.
Thank you very much.
Okay. Now calling case number 233479888. Danny D. Brown versus Larisha Whitfield of 2627 Pasadena, apartment 2W in the city of Detroit. This matter is scheduled for pretrial on a complaint to recover possession of property. May I have your appearance, counsel? Thank you. Good morning to you, Attorney Brandy. Is Larisha Whitfield here? Or, yeah, Larisha Whitfield, are you present or is she in the hallway? Thank you. Okay, thank you. The court notes that the defendant has failed to appear. Attorney Brandy, you have the floor.
Your Honor, we move for a judgment of the complaint for possession was filed when we appeared on May 25th in the pretrial. At that time, we know that he has a personal service and services.
Thank you, Attorney Brandy. The court does have a copy of the deed. The deed conveys the property commonly known as 2627 Pasadena in the city of Detroit to the plaintiff, Danny D. Brown. And this was executed on July 7th, 1987, and recorded by the, did I get that right? Recorded by the Wayne County Register of Deeds on May 1st, 2007. Also, there is a proof of service in the file indicating that the defendant was served. How was the defendant served, Attorney Brandy?
The defendant was served by the process server of this court.
By posting? It looks like posting. It's incomplete. I don't know because it's incomplete, but I will say this, the defendant did appear at the last court hearing.
Yes.
It looks like it was by posting on May 19th, 2023 at 1:30 p.m. There's also a summons, a complaint to recover possession of property, and a notice to quit to recover possession of property that was issued to the defendant at the subject address. And that was on March 13th, 2023 by first class mail. And it demanded that the defendant vacate the property by April 15th, 2023. So yes, this proof of service indicates service by posting. I already noted that the deed was in the file. Let's see. The defendant was present at the last hearing and did receive notice from myself to her to appear at today's court hearing. Additionally, the court did issue notice to appear, and that was issued on May 25th, 2023. The defendant, having been properly served with notice of these proceedings and specifically of today's court hearing, the defendant having failed to appear at today's hearing, this matter having been scheduled for 9:30 and now being 10:40 a.m., the court is going to enter a default judgment of possession. Well, let me ask you this, Attorney Brandy, is she still in the house?
Yes, you.
Okay, so the court is going to issue a default judgment of possession. She is to vacate the premises by, what's today? Today's the 12th. June 30th. Defendant is to vacate by June 30th. That is the judgment of the court. Do you have a judgment with you today? Okay. Thank you. Okay, I've signed the judgment. That concludes this matter. Thank you.
Thank you.
You're welcome. You too, thanks. Now calling case number 233480001, 11619 Bellatier LLC versus Sandy Gardner and all occupants of 11619 Bellatier Street, number 304 in the city of Detroit. This matter is scheduled for pretrial on a complaint for non-payment of rent. May I have appearances, please?
Good morning, Your Honor. Next, number 77071.
Thank you. Good morning to you, Attorney Maximoff. Is Sandy Gardner present or any occupant of 11619 Bellatier Street, number 204? I'm sorry, 304. Okay, the court notes that it's received no response. Are you checking officer in the hallway for Sandy Gardner? No? Okay. The defendant has failed to appear. Attorney McIntyre, you have the floor.
Your Honor, this is document of action. Defendant have been failed to appear. We would ask that a default judgment be entered. The rent to remain possession is $3,010 plus upon 60, totaling $3,170 to be paid within 10 days from today.
Okay. So there is a summons, a complaint, non-payment of rent in the file, as well as a demand for possession for non-payment of rent that was issued to Sandy Gardner and all occupants of 11619 Bellatier, number 304 in the city of Detroit on May 1st, 2023. There's also a warrant in the file conveying the property commonly known as 11619 Bellatier in the city of Detroit to 11619 Bellatier LLC. This conveyance took place on April 23rd, 2019. Well, it was recorded by the Register of Deeds on April 23rd, 2019. There's also a lease agreement in the file. It is between Golden Key Real Estate LLC and that was the property manager, I guess, at that time. And the defendant, Sandy D. Gardner. And that was executed on June 9th, 2021. Okay, there's also a proof of service indicating that the service was effectuated by posting at 11619 Bellatier, number 304 in the city of Detroit on May 17th at 3:55 p.m. The court notes that the defendant failed to appear at the first hearing held on this matter. However, the court did issue notice to appear for today's hearing, and that went out on May 25th, 2023. Defendant having been properly served with notice of these proceedings and specifically today's court date, the defendant having failed to appear, this matter having been scheduled for 9:30 and now being 10:45, the court is going to grant a default judgment of possession. The defendant is to pay $3,070 or vacate the premises by June 23rd, 2023.
Your Honor, maybe I misheard, but it's total 3,107.
What did I say?
I believe you said 3,007, unless I misheard.
You may have misheard, I may have misspoke, but I have written down $3,170. Okay, so defendant is to pay $3,170 or vacate by June 23rd, 2023. That is the judgment of the court. Plaintiff has presented a judgment. I will sign it now. That concludes this matter. Now calling case number 233480006. This is Gregory Franklin versus Ebry Benton and all occupants of 15510 Littlefield Street, upper unit in the city of Detroit. This matter is scheduled for pretrial on a complaint for non-payment of rent. Is the plaintiff present today?
No plaintiff, just the defendant, Judge.
Okay, ma'am, please step up. Good morning. What is your name?
Good morning, Your Honor. Abria Benson.
Abria Benson. Good morning to you. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You can lower your hand. Ms. Benson, have you been in contact with the plaintiff in this matter?
Yeah, I actually talked to them this morning, so we have a date, confirmed for payment.
Okay. Did he indicate that he was coming to court today?
No.
All right. So if you all have worked it out, that's great. It's his burden, it's his case, so he needs to come to court. Since he has not come to court, I'm dismissing the matter. Okay. All right, so I'm going to complete this dismissal order. My clerk will enter it. Please wait in the hallway for your paperwork and you will receive it shortly. Thank you. Now calling case number 233480015, Bezrat Tebeji versus Lucretia C. Wright and all occupants of 16919 Grigg Street in the city of Detroit. This matter is scheduled for pretrial on a complaint for non-payment of rent. May I have appearances, please?
Court Honor Brian Rude, P7701 on behalf of plaintiff.
John Bond, PM 78423, on behalf of Ms. White, who was here with us.
Thank you, Your Honor. Okay, good morning to you all. Ms. White, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Thank you. You can lower your hand. To the attorneys, have you resolved this matter?
Yes, Your Honor, we've worked out terms for a conditional dismissal and I can put them on record if it works.
1 second.
Aye.
She's going on. Okay, go ahead, Attorney Root.
Yes, Your Honor, we have agreed upon amount due owed of $3,800. That is through June of 2023. The defendant will pay $1,000 by tomorrow, 6/13, $2,000 to be paid by July 7th. The remainder to be paid by July 31st, and that will be, July rent will be added to that amount. The plaintiff has agreed to offset the amount owed by showing of a receipt related to a roof repair that has been paid. The tenant has agreed not to interfere with any further repairs, within 24 hours in advance.
All right, so the roof repair, how much was that roof repair?
Approximately 500.
And does the $3,800 figure account for the $500?
It does not account for that, but it will be deducted when the defendant shows the receipt.
Okay. Attorney Bonds? All right, Ms. White, did you hear the terms of the resolution that Attorney Root placed on the record? Is this a conditional dismissal or consent judgment?
Dismissal, Your Honor, will be checked.
Okay, thank you. All right, so Ms. White, did you understand those terms?
Yes, ma'am.
And did you have an opportunity to speak to Attorney Bonds regarding those terms? And do you know what you're supposed to do under those terms?
Yes, ma'am.
And do you agree to those terms? Okay, so this is a conditional dismissal, so your matter is going to be dismissed, but that dismissal is predicated on you doing what you're supposed to do under the terms that were placed on the record. Because if you don't do what you're supposed to do, then the plaintiff can come back to court and ask that the matter be reinstated, that a judgment be issued against you, and that a writ of eviction be entered, all at the same time. Okay, because box 4B is being checked on the conditional dismissal, if the plaintiff does come back and make that request of the court, he or she does not have to serve you with notice of that request. Do you understand that?
Yes.
Okay, and do you understand that if the court does ultimately reinstate the matter, issue a judgment, and sign a writ of eviction, then that gives the plaintiff the authority to come out to the property and with a bailiff and a dumpster to set your personal belongings into the street? Okay, so in order to avoid that, please make sure you do what you're supposed to do under the terms that were placed on the record. Do you all already have the conditional dismissal drafted? Ma'am, did you sign the conditional dismissal?
I haven't signed it yet, but I also would like the total added on with July's rent on my paper, and I will be able to sign it.
Just the total, including July.
That'll include June.
Yes, I would like the whole full total for I sign.
So 3,800 is through the end of June, right?
And then the 650 added for July.
Okay.
I can put that on the sheet of that.
All right.
That's all that I want.
Okay, so do you know what that amount is, Attorney Root? So the total amount will be what?
$4,450.
4,450. Up to July 31st. And does that take into account the $500 roof repair?
No.
All right. Okay, so it sounds like you all know what the terms are and have worked them out. If you can memorialize them on the conditional dismissal, Ms. White, please sign the conditional dismissal, and then I'll sign it once it's presented to me. Okay? That concludes this matter. Thank you.
Thank you, Your Honor.
And you'll present it today, correct?
Yeah, I'm just gonna double check your counsel.
All right, thank you. Ms. White, just have a seat in the hallway. Thank you. Now calling case number 23348-052, Charles Plant versus Jalen Mosley and all other occupants of 415 Manastique in the city of Detroit. This matter is scheduled for pretrial on a complaint for non-payment of rent. May I have the parties on this matter step up, please?
The plaintiff is on the left side.
Good morning, sir. What is your name?
My name is Charles Plant.
Okay, Mr. Plant, hello. And what is your name, ma'am? All All right, Ms. Mosley, good morning to you. Can I have you both raise your right hands? Do you both swear or affirm to tell the truth, the whole truth, and nothing but the truth? Thank you. You can both lower your hands. Okay, we were last in court on May 25th. Mr. Plant was here. Ms. Mosley, you were not here on that day. Have you all resolved the matter since then? Okay, Mr. Plant, how much is owed in rent? $4,900. How much is monthly rent? All right, Ms. Mosley, what do you have to say in response?
So there is a reason why I stopped paying the rent is because of the way the house is. I did have a report on the house. It is at culminating so I've been calling and asking to have the house fixed. No one has appeared. At first he did start fixing the house, but my ceiling fell on me. The house is just breaking down. I have a daughter. I am a single mother. I work a 5-to-5 job. And she has developed bronchitis due to that as well.
Okay, so so the ceiling fell. Is the issue the roof?
My kitchen ceiling and my bathroom ceiling. I have mold in my bathroom.
All right, Mr. Plant, has the defendant requested that you make repairs to the home?
No. I was in compliance.
All right, ma'am, have you spoken with an attorney?
I have, yes, and they told me that after the report was made, that I was able to make repairs in the house, but due to me being the only one there, I have tried and it's a lot of time. And I have been giving him a call. He hasn't been answering. I did let him know that as well.
So did you speak with an agency attorney is what I mean?
No.
All right, well, firstly, Mr. Plant, I don't have a lease agreement or a deed. Do you have those documents? Can you have a copy for the court file?
No,
Okay. We need those documents for the file. So, I thought I said that at the last court hearing. Can I see the documents? Can you give them to the bailiff? Thank you. Is this your only copy, sir? Of the. All right, so the court does have a monthly rental agreement, which was executed on March 20th, 2020 between Charles Plant and Dakita Plant, the landlord, and the tenant Jalen Mosley of 415 Manistee in the city of Detroit. It does indicate that the rental amount is $700 a month. Ma'am, have you been holding the rent, like in a bank account or escrow?
I had at the beginning, but my job made me off. I used to work at Amazon, and it took me a little second to have another job. So I do have another job.
So has the ceiling been repaired yet, Mr. Plant?
This was a sale case. They paid the rest through October.
Mm-hmm.
It's possible to rest.
Okay, so Sarah paid through October of 2022?
Yes.
All right, but what about the repairs to the home? I'm asking about the ceiling that is caving in. Ma'am, did you tell the landlord that the ceiling was falling in?
He came and fixed the bathroom ceiling, but it collapsed again. I have pieces of my ceiling, the wall, like I said, is mold in my bathroom, and it's also on the outside of the house as well. My daughter developed bronchitis. I have medical bills.
Okay, I'm gonna stop you. Can I have an attorney speak with the defendant in this matter? I'm gonna pass on this matter for a moment to have the defendant speak with an attorney. Mr. Plant, I'm going to give you back your lease agreement since it's the only copy that you have. But I do need a copy of this somehow, some way. So I'm gonna pass on this to allow for you to speak to an attorney. I'll recall this matter in a little while, Mr. Plant, okay? Thank you. Now calling case number 23348-015.
Already called out.
Oh, okay. Thought I was having deja vu for a second. Strike that, Madam Court Reporter.
Okay.
Thank you. Okay, we are moving to our 9:45 docket. Now calling case number 2397678, Mac Ashland 1 LDHA LP versus George Price. And all occupants of 14711 Mac Avenue, apartment 215 in the city of Detroit. This matter is scheduled for a pretrial on a complaint to recover possession of property. May I have appearances, please?
Morning, Joe Work of P75969. I'm sitting in the Mark Lane.
Your Honor, Joe McGuire, P75571.
Thank you, sir. Please state your name.
George Price.
Okay, good morning to you all. Mr. Price, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Thank you. You can lower your hands. To the attorneys, have you resolved this?
Well, Your Honor, I was contacted by Lakeshore Legal Aid, who informed me that they had to withdraw from this case because of conflict of interest issue. And so that was just on Friday. So
Okay.
I haven't had a chance to review the file. I did speak to Mr. Horka out in the hallway earlier today. And as I understand it, there were discovery requests from the defendant to the plaintiff in this matter that have not been delivered yet. So I talked to Mr. Horka about working out the discovery issue and hopefully coming to a resolution for the next court date. As I understand it, Your Honor, this is set for a pre-trial, so maybe we'll set a trial date today, and hopefully before that we'll have the discovery. Have a resolution.
Okay, and thank you for that, Attorney McGuire. I will note that now that I'm looking through my notes, there is a note in here from May 30th, and I think that is when Attorney Smith made an oral motion to withdraw as attorney. There is an order for withdrawal of attorney here. I did grant her oral motion back on May 30th, and so I'm going to sign that order now. Just as a matter of housekeeping. And then what can someone tell me what the issue is?
So the discovery issue?
Yes.
So this is a termination for cost on subsidized housing, and so my understanding is there might be closed circuit television video that is relevant in this case. And so we were requesting that from the plaintiffs, if that exists, or any other documentation that the plaintiffs might use or want to use, what witnesses they might bring in the case of the trial, that kind of thing.
Okay, yes, I remember this. Discovery had been authorized previously, and Attorney Smith made a motion to continue discovery at least until today. But it sounds like, can I ask you, Attorney McGuire, are you from the other agency or have you been retained?
So, Your Honor, I'm from Detroit Justice Center, which is another nonprofit agency. We are not the agency.
Okay.
Lakeshore or United Community Housing Coalition that takes, a whole lot of land for tenant cases, but we do take some. That's why.
Okay, so I am going to adjourn this matter. Let's see, Well, Attorney Parker, what do you have to add?
With Mr. McGuire just getting contacted on Friday, I understand he's not gonna be able to proceed today. Be in contact with them to exchange this discovery now that we know who's involved in the case. If the court wants to set up like another pretrial in about 3 weeks, or if you want to set up a bench trial at this point, I'm fine with you.
I will set it for trial, but I don't, once I set cases for trial, like, I don't like setting like 3 and 4 bench trials on the same day with the hope that they're going to resolve and then, oops, I have 4 trials to handle, or, you know what I mean? Like, I'd like to know there's actually an issue for trial before I set it for trial. So what I'll do, since we are just having another defense attorney come on, is I'll schedule it for another pretrial. And so he said 3 weeks out. This is June 12th. Let's see. That takes us to the week of July 4th.
Week before, the week after. Or that week if you guys.
We have July 7th.
No, I get it. I don't, what'd you say? So we'll do July 11th. Okay. Let me give you a time. Okay, so we'll schedule this for July 11th at 10:45. July 11th, 2023 at 10:45 a.m. That'll be in person. Mr. Price, you'll come back down to this courtroom.
Yes.
Okay. All right. Thank you. Oh, so discovery is still open until at least the next pretrial date. You're welcome. That concludes this matter.
I don't know, contains documents, but I was gonna have them get filed, if you didn't have them today.
Thank you so much. I will definitely take them. Can you just give them to the court officer? Thank you, officer. No, I won't. Just sign that order, allowing attorney to file, Madam Clerk.
before I register something, because I'm thinking I'm frauded all the way around, and then I'm receiving eviction papers for something that I have a purchase agreement from Mr. Stanton. So that's why I was never registered on my behalf, because Mr. Pepper told me to get out.
Okay. No, I've heard enough. I'm not prepared to enter a judgment today. Mr. Stanton, you said that you have a case in small claims, which is confusing to me, because if this involves property, I don't know why it's not in Wayne County Circuit Court for a quiet title action, but I don't know. I'm not out there practicing law. So I'm going to adjourn this, I suppose. Attorney Norsegian, what are your plans with this case?
Well, at this point, it sounds like, well, I'm definitely gonna file a quiet title in this case, to clear all Mr. Stanton's deed up. I mean, I suppose I'm gonna put Ms. Messner on the quiet title as well, because she has a deed that's not recorded, but we know she has a deed, so we're gonna have to quiet her title as well. In the meantime, I would ask that the court enter an escrow order, of, I don't know, $800 a month. Let's see, today's the 12th.
I'm not going to do it. You've just acknowledged that Ms. Messner has been defrauded and she's living in the house and she paid money for the house. You know that, right?
Well, he's saying that it was a lease with an option to buy. She said she had a deed to the property. I don't really know where we're at with that, but I think someone should, if they want to continue this case, I think someone should have to put up some money to show that, hey, we're actually involved in this case. You know, we have the two legitimate deeds in this property. Period. No one has said our deeds are fraudulent. Our deeds were recorded before the deed to Mr. Stanton. You know, he's the one that needs to come here and say, hey, your deeds are fraudulent, my deed's the real deed, because his was recorded after. So the responsibility is on him for that.
So I'm not ordering escrow, Attorney Norsegian. Okay. Because to me, all of it is questionable. I mean, but you know, that's what the Wayne County Circuit Court is for, you know, to make that determination as to who has the valid deed. So what I'm going to do is adjourn this matter. Have you spoken to an attorney, Ms. Messner?
Listen, the housing commission, I'm gonna contact them and see if I can, Justice Howard, another attorney, I'm gonna contact them. Because it's a complexity. This is getting way over my head.
Well, have you refused legal services in the past?
I did talk to a legal aid person here. His last name is Kruger or Cregan or something. I spoke to him. He decided that he did not want to proceed on it. And so I need to do something.
Attorney Krager, can you place your appearance on for the court reporter?
Yes, Your Honor. Matt Krager, Michigan, Legal Services, P79510. I did speak with Ms. Messer quite a few hearings ago. I did advise her as for a particular case. However, I did not receive any of her documentation. I indicated to her in advice-only capacity what her options were, including any in terms of the quiet. Unfortunately, we do not have the capacity to do all these quiet right now, but she could certainly contact the court justice.
Thank you, Attorney Krager. So, let's see. So the plaintiff in this matter is AFO Global Enterprises, LLC. Attorney Norsegian, you've presented me with a management agreement between the purported owner, GJP 2018 LLC. Well, I do have a deed saying that they are the owner, but I also have a deed saying someone else is the owner. Okay. And AFO Global Enterprises, LLC, but it's not signed, it's not dated. So, you know, I have an issue with that. This is something that was typed up. This looks like I could have typed it up, you know, manipulated the fonts. And when it comes to the signature, I manipulated the signature block. This is not a signed document.
I mean, I take a little bit of offense to that, Your Honor.
I'm
not gonna sit
sorry,
here and
but
risk my legal career to manipulate, property management agreements.
I didn't say you manipulated it. I mean, no, you shouldn't take offense. I'm just stating what the court, I mean, you see this. This is a typed document. There's nothing in here that indicates that this was executed by anyone. Is this Brian Pepper's signature? Or is this a computer font?
It looks like an electronic signature. It doesn't look like a handwritten signature. I'll agree with Your Honor on that.
Well, no, I don't know that. Well, when you say electronic, do you mean like how you do the e-sign or the VeriSign? Because there's a difference.
It doesn't look like he wrote it with a pen.
Right, it doesn't look like he wrote it with a pen, and it also doesn't look like a VeriSign document because usually there's some kind of stamp that shows like what do they call it? The
date?
No, not the date. The it shows like the address to the website. I can't think of the terminology, but it's not this. It's not just somebody's type name in italics or cursive, where the font has been changed. I've seen e-sign. I practiced for a long time. I know what they look like, and I know what they look like when they're printed up. So please don't take offense when I'm just telling you what I see. This does not look like even an e-signed document. So, I'm not trying to offend you, but that's just what I see. So that's why I take issue even with the management agreement.
Okay.
So do you have one that is signed and that was signed before you sent this notice to quit?
That's the management agreement that he operates under. That's the management agreement. All the management agreements I submit on behalf of this client look similar to that. If Your Honor wants a separate wet sign management agreement, then I can bring that to our next hearing. As I stated, if we have the next hearing in the next couple of weeks, I can for sure guarantee that the client will show up because I know that he's in town through at least June 23rd. I'm going to tell him today when I walk out of here that we need to file a quiet title, and then I'm going to file that as well. And if there's anything else, Your Honor, things that the court file needs to make it a little more clear what's going on here, I can provide that. But, off the top of my head, I think those are the best tools at my disposal right now. And again, I would ask for, a court date in the next, around June 23rd, because again, I know for sure he's going to be here then. I'll bring him back here and then he can tell the court himself exactly everything that I told you, provide a wet signature on the management agreement. And, again, he can verify the deeds.
So this is my thing. Is this the management agreement that you submit to this court every time they're want to support AFO Global?
For that client, yes. It's not exactly that, but it looks pretty darn similar to it. The signature looks the same.
Now I want to pull another AFO Global file just to see, because to me, this is not signed. This is not a signature. I know we're in a world of, electronics, but I know what an e-signature looks like, and this doesn't.
As I said, since Your Honor does not, since that management agreement doesn't pass the smell test of the court, like I said, I can ensure that my client, I'll have him provide a wet signature management agreement. So there are no further questions regarding the management agreement, because I think I don't think that that's the main issue here, but I can clear that.
Well, it's an issue for me because if you don't have a property management agreement, your client doesn't have standing to proceed today. So it is an issue. Right. I mean, it's an issue.
I understand that, Your Honor. And again, I will make sure I receive and provide a wet signature management agreement. So there are no questions whatsoever regarding the veracity of that document. Again, and I will provide the case number of the quiet title case that I'm going to file this afternoon. And and again, if we can do this in the next couple of weeks, I can guarantee that my client will be here to provide testimony to Your Honor, so you can size them up yourself and see, what's what.
Crown, may I ask address the clerk?
Very briefly.
Okay, I'm looking at the date of August 1st, 2022 on this management agreement. And I bought the house on August 20th. So that date is a little off for me, just from that standpoint, the first part of the first sentence. Because the demolition people told me that the house was uninhabitable and they put it on the list. That was on August 5th, roughly. August 5th, if I remember correctly, with the demolition department told me. So I don't know how this was even made if the demolition people came out and told me that I had to, they wanted to put the demo signs on the house and everything. This is made on August 1st, and I bought it on August 20th. So the dates are not even matching.
1 second, please.
I don't even know how that's works.
I just asked for a second. Ma'am, this is why this needs to be worked out in Wayne County Circuit Court. There's nothing for me to do right now besides dismiss the case because of, I mean, I know you all are caught up on, you know, who has the valid deed, but my thing is, even if there's a valid deed, there's no valid property management agreement. It doesn't, and that coupled with all of the other shenanigans, is the word you used, Attorney Norsegan, it makes me very leery about proceeding with this case.
Okay, well, again, I would ask that you allow me to provide a wet signature management agreement at our next hearing. Again, I can bring the client in to give testimony to your honor, supporting everything that's been said here today. And then I will provide the court with the case number on the quiet title that's about to be filed.
Okay, and then once the quiet title is filed, I mean, you know, there's gonna, I'm sure the court is not going to make an adjudication on that immediately.
No,
So,
of course not. I mean, I know standard procedure, you wait to the end of the quiet title.
Right.
At that point, I mean, full disclosure, I'm gonna ask the court to revisit the issue of escrow at that point, but, you know, I understand that there's no order of that right now. I understand that.
okay, so I'm going to adjourn this matter. Madam Clerk, what date was that you gave me?
June 29th.
Is your client going to be here June 29th?
Don't know about June 29th. I know for sure by June 23rd.
Well, if he wants to proceed with this action, he needs to be here. June 23rd is not a good date for us. Yeah, we are well beyond that date. So June 29th is going to be June 29th, 2023. And we'll schedule this one for 11:25, just in case we have to take testimony. This matter is adjourned to June 29th, 2023 at 11:25 a.m. The hearing will be here in courtroom 433 in person. Mr. Norsegan, please make sure your client is present. And if he can't be present, please call the court clerk to let us know. And we'll try to get an adjourn date, but I mean, we can't plan our docket around your client's schedule, okay? All right, that concludes this matter. Thank you. Yes, ma'am. I have it. Thank you. We're gonna actually take a break. Let's see. Attorney Bajani, I think you're up next. And we have Attorney Bajani and Attorney Fluker. Is Attorney Fluker here? Oh, okay. Have you all spoken? Have you spoken was my question. All right. You all can speak because we're taking a break. Attorney Bajani, you also have a trial scheduled today. What's the status of that one? No. Is mutual property management? Okay. All right, so court is in recess until, does that say 11:37? Court is in recess until 11:55. When I come back, we will hear Attorney Bajani's and Attorney Fluker's case, and then we have two other matters. I think one other matter to handle. But it's in recess until 11:55. we're back on the record. I am going to call Attorney Brayley's matter first. And I don't even have a file for that one though. Oh, right here. Which one is that?
That's the next one.
1125?
Yes.
Okay.
They have two, one pretrial and one motion.
Okay.
But she did, they have to issue this. And the defendant.
He was cut.
I can't.
For attorney.
Is that what?
Oh, wait, hold on. Please go back on mute. Okay, good afternoon.
Good afternoon, Your Honor.
Are you for the plaintiff or the defendant? Okay. It's been a long day. Are we ready? Ready?
He's on his way back in.
Okay.
A little temperamental.
All right.
Try to go quickly.
Okay. Okay, now calling case number 2238657, Bill Properties LLC versus Bobby Menifee and all occupants of 16626 Monica in the city of Detroit. This matter is before the court on a pretrial and a motion hearing. May I have appearances, please?
Kimberly 579685 on behalf of Bill Properties, Your Honor.
Mrs. Hillary Brayley, P number 82889, here on behalf of Bobby Menifee, who is here behind me. Mr. Menifee, can you state your name for the record, please?
Bobby Menifee.
Good afternoon to you, Mr. Menifee. Thank you.
How you doing?
I'm great. Thank you for your patience today. Can you please raise your right hand?
Yes.
Just
what
put it
you
up.
want me to do?
Just put it up. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can lower your hand. Okay, how do we want to proceed today to the attorneys?
So at this point, Your Honor, I'm happy to report that we have a conditional dismissal. If you want me to read the terms onto the record.
Please do.
Okay, Mr. Menifee will vacate property by July 28th of this year. This is a voluntary move. The plaintiff is going to provide a neutral reference in order to preserve his Section 8 voucher. UCHC is going to reissue a SARA check in the amount of $1,610, and that'll go directly to the plaintiff. 4B is checked. Well, I'm sure if we need to reinstate that, sister counsel will send me an email to let me know. Box 7 is checked and all parties have signed, Your Honor. I have 4 copies. If Your Honor is willing to sign this right now.
Thank you, Mr. Menifee. Did you hear what your attorney just stated on the record?
Yes.
Do you understand what you have to do in accordance with the terms that she just placed on the record?
Yes.
And did you have an opportunity to talk to your attorney about the terms that she stated?
Yes.
And do you agree to the terms?
Yes.
Okay, Mr. Menifee, you're supposed to leave your current residence by July 28th, 2023. Do you understand that this matter is being dismissed pursuant to the conditional dismissal, which requires you to move out by July 28th. But if you don't move out by July 28th, the plaintiff can come to court and ask that the matter be reinstated, that the court issue a judgment against you, and that the court issue an eviction writ. Do you understand that, Mr. Menifee? If you don't move out, that's what will happen. Do you understand?
Yes.
Okay, and because box 4B is checked on the conditional dismissal, if the plaintiff does come back to court and asks me to sign off on these things, they do not have to serve you with notice. Do you understand that?
Yes.
Okay, but I think the attorneys have worked it out where if that should happen, the plaintiff's attorney will contact Attorney Brayley. Mr. Menifee, did you sign the conditional dismissal?
He did, Your Honor.
He did?
Yes.
Okay, so did you place, can I have the conditional dismissal?
Hold on top of the original.
All right, thank you. Mr. Menifee, is this your signature on the conditional dismissal on this bottom line here?
Yes.
Okay, all right. Is there anything further from either party?
No, Your
Honor.
All right, so the court is satisfied. I'm going to enter the conditional dismissal. I'm gonna sign it and we will get you on your way, sir. Thank you so much for your patience.
Okay, thank you.
You're welcome.
Thank you. All right.
My date stamp just disappeared. One second, I'm trying to get Mr. Menifee out of here. I'm getting his paperwork together. Here's my date now. Is there anything else that needs to be called before I go back on the record with Attorney Bajani and Attorney Fluker?
Just up to try.
Ogletree.
That's it.
Attorney Ogletree, is he here?
Yes.
Is representing me?
Okay, is Attorney Ogletree here?
Yes.
Yes, he is,
He
Your
didn't
Honor.
check in, Judge. He
But
might
I
know
don't
the
know
matter.
who he is at the moment. He is
He's
in
at
another
538, he
courtroom.
was. I'll take a look. I'll get it.
Yes, Judge, we submitted a proposed dismissal for that matter. I'm not sure if you have those.
Yeah, I'll take it.
Dismissal should be on first.
All right, thanks. Sorry, I have to go off the record really quick. I'll be right back.
And this is. 2565.
Okay, 52565.
How you doing? I'm all right, how are you? Good.
It's coming down here, 433. Okay. You just left, you think it's coming down. Here he is, I see it.
Hey, how you doing? Good to see you. How you been? Good night. Yeah, thanks. CD.
What was the case?
It was back in March. On the record, I passed it twice.
I'm okay.
Thank you so much.
You're welcome.
So, wife was Ralph and Pete, were you still playing with him? Ralph Bunch, you still there?
Oh, I don't do rough budget. That's it.
Oh, 50 years, okay, I don't understand the
Yeah,
Oh, okay.
yeah, so, there was a lot of changes over
Yeah,
there. Do you still have anything going on over there?
I have it a lot, that's not good. Last thing I had is.
Oh, man.
I'm gonna get 8,000 calls, but
What about that one in circuit court? The guy who's
it's still there.
just doing nothing?
It's still there. And it's still wrapping crap on it.
Hmm.
This is, this is crazy.
The co-op's always hard. Yeah.
Yeah,
All right, well, good seeing you.
good to see you too.
Yeah. You get a special idea to come in here?
No, you know, I just stuff. I have to do this.
Oh, okay.
Okay, but they, soon she'll be back in a
Well, you got
minute.
to come
She
to
was gonna
judge's
call you
door or
on how to.
Yeah, right.
She's getting ready to call you guys.
Yeah.
Because they said it was a.
My client is objecting to it, so we'll see how the judge.
Oh.
No blooper line.
We'll just
I
have
know
to see.
that was right. You know that was right.
All right, see you
Okay,
later.
take care, bye.
All right, we're back in session.
Court back.
I need to mute. Okay. All right, so we are back on the record with ACP Nash LLC versus Rolando Campbell. This is case number 19361-180 SP. And can I have Plaintiff's counsel, place your appearance on the record again. And Attorney Fluker? Mr. Campbell, please state your name again. Okay, thank you. So I'm sorry I cut you off, Attorney Fluker. I don't remember what you were saying when I just had the thought come into my mind to go make a phone call. But what I do want to note is that, well, first of all, go ahead and finish what you were saying.
I was talking about the order and without prejudice. And I'm not getting ready to go through the black law dictionary definition or whatever. But the mere fact that it is remanded back down without prejudice to a summary proceeding, the summary proceeding file, meaning that there's some type of anticipation that there would be a correction or whatever the case may be, would be brought back up.
So Attorney Fluker, I looked at I think, is it Exhibit 4, which is the claim of appeal that you filed with 36 District Court? Exhibit 4 to your motion. This one is not time or date stamp. Do you have a date or time stamp copy from 36 District Court or a receipt that you paid for the claim of appeal?
I don't have it. We got the email was over. I was trying to travel light, not bring Walker.
Well, that's the thing. Maybe that's why it's not in the register of actions, because it wasn't paid for.
No, that's not true. And I had that conversation with Mr. Jackson. Actually brought him down a copy of everything he was going to do.
Okay, well, I need to see a copy. And I need to see it quickly, because without that, I'm not even going to say without that, but that's an issue. That you've made that a big issue in this case, that the claim of appeal was not showing up on the register of actions. And I can tell you that that would be one reason why it wouldn't show up, is if it wasn't paid for. Also, I don't have a date stamp copy of the claim of appeal. What you've attached to your motion is it is a claim of appeal. It has the district court number on it, and it has, a spot for a circuit court number. I presume that's because this was prepared before you filed it with Wayne County Circuit Court. But I don't have anything that shows that the court actually accepted the claim of appeal, or like I said, there's no receipt. So if that is the issue, then, that just is what it is. Also,
Can I respond to that?
quickly,
Okay.
because I just want to say we're well past the time that I go to lunch, and that's not your fault, Attorney Bajani, but I don't want to have to recall the matter after lunch. So, because I'm going to tell you what I'm going to do. I'm not entering the writ today. I need to see the receipt and a time-stamped claim of appeal. And I think you should be able to get that by tomorrow, right, Attorney Fluker?
Yeah.
Are you in here tomorrow, Attorney Bajani?
Yes, sir. But what I was gonna say is that even if she does provide those documents, I still don't see how that would be relevant to this matter.
Well, because she's saying that the claim of appeal was, lost or whatever, and that caused her to somehow not be able to. You heard her arguments. I'm not saying I'm in agreement with it, but it is an issue for me. I am concerned that if she filed something, it wasn't, properly before the court.
I think I might have your email, not if I did, because this was actually done by a fee waiver, and the fee waiver had to be signed by this court and the circuit court.
That would have been, okay, so you don't have that with you either?
No, I travel kind of light, because I can't really look at it.
I understand that.
Judge, first, this is our 28th hearing in this matter. I just want to know that you're aware. After 4 years and 28 hearings, I find that you're responsible not to bring all the documents you wish to present to the court upon request. I have every document that you requested of me, but most importantly for the appeal, there is no bond that was issued. The defendant is required to post a full bond and located in the judgment with the court.
a zero bond was issued, and that's why they can they can use the appellate program, and they have once and twice, and delay the case for a year after year after year. And at the same time, my client is paying for all the expenses, homeowners insurance, property taxes, water bill. All for the defendant on the defendant's behalf. And my client is losing money, the defendant is living in the property at my client's expense.
First of all, Your Honor, that's what I was talking about.
To get the what expedited? I'm sorry, the printer is going.
The reason there's no bond is because Judge Garrett said she was gonna hold a hearing to see if the my half money could be used for the bond. I filed a motion for escrow and
That's not even what's before the court right now. We're beyond that. I know he raised it. We're beyond that. There's a judgment.
Well, the judgment, but we appeal from.
But the appeal was dismissed.
Without prejudice.
Okay, but you didn't refile it. And that's what you're saying, but what you attached to your motion does not support a claim that it was actually properly filed with 36th District Court.
I know the file was voluminous, but I can see it's probably in the file, but I will email that over to you.
No, don't email it to me. Bring it back down here, please. And you know, hopefully you kept the receipt of payment, because that is really germane. And I have the file in front of me, you know, let me see here. Maybe it's in here.
The payment is going to be the copy of the fee waiver.
Yes, I'm looking through the file and I don't, oh wait. I don't see an actual claim of appeal in the file. Now, like you said, it is voluminous. But you know, that's neither here nor there. We are at the point where we are about to start talking about a move out date, sir. So I'm just putting you on alert, on notice. Go ahead. I didn't hear you, ma'am.
He appealed to the further offset of a property that was sold to him with some defects that were known. And he never had the opportunity to tender anything. The redemption period did not expire. Allegedly, the circuit court order came back down
Well, that's not allegedly. The circuit court order did come back down.
It came back down without prejudice, and I was gonna get to that in a minute, because you have without prejudice that anticipates some type of remedy. And I filed this motion in January. I didn't file this motion 2 weeks ago. I filed this motion in January as soon as I found out. And based on the time of the filing the appeal, which was on June 7th, that, the redemption period is already stated at that point. The order was made the 25th. I filed the appeal on June 7th. So, for all intents and purposes.
You filed what appeal? You filed an appeal?
The circuit court.
On June 7th?
That's right.
And it was not dismissed until, where is it?
October, because it was still trying to get all those, like you said, this is the 28th hearing or whatever. Well, a good 17, 18 of those were actually trial dates. And all those transcripts had to be generated. And circuit court obviously got tired of waiting, which is why it was dismissed without prejudice. And I am just saying, we all know how the process is. It's not like you have a straight 2, 3, 4 day trial. It's been blocked whenever it can be fit in.
I practiced law for a while, Attorney Fluker, and I listen.
Yeah.
In back court between 3 or 4 different courts, and yes, it is hard to track down the court reporters, but it's not that hard. You just go to the court. You just go to the court and say, who was the court reporter on this day when I was, when I had a hearing.
If you look at it, that's what I'm saying. It's not like they weren't ordered, they weren't ready. If you look at my exhibit.
Judge, all these issues, my client should have liked the board for that. That's not my client's problem.
Well, these transcripts were ordered on June, as copies attached to the brief. One set was ordered from one court reporter on June 7th. There's several different court reporters. Another set was ordered again on June 7th at 3:12. They were ordered from different court reporters, and the receipts, request receipts are a part of the exhibit here. I can't go down there and do the transcripts.
No, you can't, but you can alert the circuit court that there's a delay.
And I did. And that is why, in fact, my legal assistant did, of course, and that's why it was dismissed without prejudice and not with prejudice, which is a big difference, and we know that.
No.
If you just have a straight up defect, you just aren't complying with nothing, you haven't contacted the court or anything like that, they aren't dismissing a summary proceeding appeal without prejudice. In fact, if you go back and look and see how many summary proceeding appeals are dismissed without prejudice. Very few. But in this particular case, there were just a voluminous number of dates.
Okay, I understand. I empathize, but no, Attorney Fluker, it is time. This is a 2021 case.
You know what?
Oh, I'm sorry, 2019 case.
And at what point does the due process come into play?
A due process has come into play. You have had, this is the second hearing on your ex parte motion that was filed in January of 2023. It's June. It's June.
The initial delay was not because of our fault. You look at the register at the initial delay. Look at the first judgment. Just look at the face of the first judgment. We never got it. And on the face of it, it was mailed out after the appeal period. We did not do that. They're trying to act like this delay was on us. And this is something that you can just look at the judgment. The first judgment that came out when they had to do the amended judgment, basically was accepted.
Right, but you got an amended judgment.
Exactly.
So what's the point? I mean, why are you bringing it up?
That you're saying how long this case has been going on, yourself, Mr. Johnny, like all this delay was our fault. And this delay was not our fault. It was not our fault that it was the order that specifically, No,
I'm not pointing the finger at anybody. I'm just telling you, you're saying that you haven't received due process, and I think that you have.
At the end of the day, it is my client that's suffering who has not had the adequate ability to appeal, the adequate ability to redeem. They filed a freaking writ before his redemption was even up.
That's not true.
This case was stayed until it came back down from the circuit court.
Yeah.
Attorney Fluker and Attorney Bijani, please, we're not about to do what we did the last time.
I'm just saying, just for calculation purpose. By definition, when you appeal and there's a appeal, it stays everything from the point it is at. The judgment went in on 5/25/2022. The appeal.
Okay, stop. Okay, look, let's take the dates. Talk a little slower, please. So we're gonna get the dates together. You said the judgment went in on 5/25/2022. When was the appeal filed? 6/7/2022. Okay.
So immediately at that time, the case becomes stay.
All right, hold on.
Wait, I repeat, you say the latest judgment was entered on what date?
5/25/2022. You got a copy of the judgment. I'm looking at the judgment right here.
Okay. Yeah, I agree with that.
Okay, and then the claim of appeal, you said was filed on June 7th, 2022?
Filed with this one, filed with the second court on the 6th, filed with this court on the 7th. Which immediately effectuates an automatic stay.
Okay, 1 second. So that's 13 days between May 25th and June 7th,
So you have
right?
90-day redemption period.
Okay, so that's 13 days.
You're minus 13 days.
All right, so the appeal,
The appeal is stayed. Stays everything.
stayed as of June 7th, right?
Correct. I believe the circuit court order was dated October 13th.
October 13th, 2022. So that lifts the stay.
Exactly. I would have triggered the redemption period.
Okay.
No, the redemption period doesn't re-trigger. It doesn't reset.
It's not reset, it's minus whatever days are missing from people who filed the appeal.
No, it grows. It's perpetual, Your Honor. There's no court rule that says you can
It's
keep.
not perpetual, that's why.
Don't start cutting each other off, please. Please don't do that.
Judge, there's no court rule or law that says once the case is in appeal, that the redemption period is told and the clock stops and starts over.
Well, let me ask you this, Attorney Bijani. If it's on appeal, if somebody was appealing something, why would they pay the amount that's owed? You know what I'm saying? Like, so if I enter a judgment against you for $50,000 and you appeal it, why would you then pay $50,000 during the pendency of the appeal?
Because it's a bond. That's what the whole point of a bond is, to make sure that both parties are secure. And I would have been protecting my client right now, because this case has been appealed for 3 times. Each one is 3 years, and it might happen again. And my client gets $0. Meanwhile, he has to pay for all the expenses at on his behalf, all he gets to live life. And Judge, there's also an escrow order that's been entered, and nothing has been paid for over a year and a half. It's an ongoing escrow order. I tried looking on the ROA, and they haven't been paid. And my client is entitled to some kind of recourse because of that.
How much is what was the monthly payment amount of the land contract, if either one of you remembers off the top of your head?
500.
550. And Your Honor, just so clear, I filed a motion to send it for an escrow order.
Listen, you all don't have to address every little thing that is said, because I've already said that I'm adjourning it one day.
I just want to pull up the law here from this court.
I'm not doing it. Attorney Fluker, I'm about to, this is about to be done. This is not about to turn into a 3-hour motion hearing. All right, so the circuit court issued its order dismissing the appeal on October 13th, 2022. When did you submit the writ, Attorney Bijani? The writ that was actually signed off on?
Well, I have 2 writs that were signed off on, but I'm going to give you the later date. It's April 15th, 2022.
Your Honor,
did you say 22 or 23?
Oh, wait.
Come on, now let him talk. No problem. Then you get.
Oh, I'm sorry. It was signed on January 23rd, 2023.
January 23rd. When did you submit it?
Let me see this timestamp. I can't remember, Your Honor. I submitted it. Well, I dated it, November 10th, 2023.
Let me
I almost
see.
filed it at that time. I just like to keep track of it. When I complete the document, when I file it.
I understand.
Register actually filed it.
I'm looking at the register of actions now.
Yeah, but at that time,
Before the expiration.
Do you have some case law that says that the judgment period, I'm sorry, that the redemption period is told during the pendency of the court, the appellate action? Attorney Fluker.
That's why I was getting ready to pull up and be like, shut it down. That's why I was getting ready to pull up.
Okay.
But when I bring that stuff, I can definitely bring you a 2-page memo when I would.
but Your Honor, it still runs around the basic fact that none of these even matter.
I'm sorry.
None of this even matters, even if she's successful in these arguments. What is it? What changes? It's not like we're gonna use the house for free. He's still gonna have to pay for it. We already adjudicated this whole entire case. A chunk of $20,000 has already been applied as a credit. If she wants to appeal it so bad, if anything, the court is gonna reverse and rule in our favor to add back that 20,000, because this is an as-is contract, and he had a self-disclosure. All of the defendants, affirmative defenses and counter complaint was dismissed with prejudice in this Third Circuit Court. So when we go back to that Third Circuit Court, the judge is gonna look at everything, and he's gonna reverse exactly, he's gonna do the opposite of what the school does. And I'm 100% sure of that. And then that's just gonna be a delay tactic. He's gonna send it back down, and then more motions and more dragging on. This case seems like it's not.
If I may, Your Honor, I would just say 2 minutes. Motion.
I hope.
First of all, the plaintiff appellate did not appeal. That's first and foremost. We did. Secondly, I'm kind of having a problem, not just with this case, but in general, with a lot of more foreclosure. It seems that when people of color challenge legal issues, it always becomes evident you don't have any money. No one said that my client did not have the funds and resources to redeem his property. He challenged the underlying ruling because they took a land-based property that they did not abate pursuant to the city court order and sold it like it was great property.
Okay, well, let me ask this. So that takes me to what I normally do when I have a writ hearing. Do you have the money, Mr. Campbell?
Yes. Can I speak? Yes.
I mean, if your attorney allows you to.
Yes, I have the money. The money has never been an issue, Your Honor, and I just want to say this from the word go. If I don't want to get a whole history of this case, but the initial action against Mr. Campbell and ACP Nash was filed by Mr. Campbell. I was the person who originally started this whole thing because of what they did, the house that they sold to me and the way they sold it to me. Throughout these years, yes, ma'am, I know it's been a few years, but throughout these years, if you take the time to look at the record, you will see I have never been given a fair opportunity to present my stuff. And then when Judge Millender came and gave us the numbers, we immediately appealed it. It's clear that we immediately appealed it. The transcripts and stuff is there. She never gave a bond order because I would have paid the bond order. They tried that in the case. They kept saying, Mr. Campbell hasn't paid any money. I had to go get receipts to show them that yes, money has been paid. They was trying to say I never paid a dime. That was proven to be untrue. Every single thing that they have said on the record has proven to be not true. He hasn't paid this. They're paying the taxes. They're paying the water. They're not doing none of that because I'm signed up for whole program and exempt the taxes. I pay the water bill. I know what I'm doing, but again, I haven't done anything wrong but stand up for my right because they gave me paperwork that said this house is basically brand new. When I got there, it was absolutely not. And I've spent over $75,000 repairing this property that I got receipts and stuff for. So yes, ma'am, we were a little disappointed with the offset number. And that's why we appealed it. But if they come back and they say, hey, we only gonna take another 1,000 off, or we gonna add back 5,000, we got the money to take care of it. It's never been a money issue. They try to make it a money issue because somehow that has some type of power over the court, I guess. But it's not a money issue.
And this is why I asked you all, had you spoken previously?
They won't talk. He's saying that they don't have the might have stuff. You can look at the records, Your Honor. That is a lie. We talked about my half in the court with the judge. So how could him and his attorney, his client, not know? He told the judge several times, we didn't know nothing about that. He told him that twice in 2 different hearings. So clearly you know, because we're telling you. You can look at the emails. Yes, they deal with us and they deal with them. So they've been dealing with me, and you see in the emails, they're stressing and asking to deal with the other side. The other side just would like to take the property back because of where it is at. That is the bottom line to it.
Your Honor, nothing that the defendant, we disagree categorically.
All right, you disagree with what? Do you disagree? Do you disagree with, do you want them, will you take the money now?
First of all, he doesn't have the money. If he
That's not, no, you don't know what he has. I asked you a question. Will you take the money now?
No, we won't.
Okay, so then you don't disagree. What do you mean?
The redemption period has long lapsed. And right now, Judge, the amount of the judgment has probably tripled because interest is still accruing throughout this time. Right now, so even if we satisfy this case, let's say he does pay me the 56,000, then we're not gonna give him title. We're gonna have to start all over again.
Well, don't put don't put don't put like speculative statements out there if you're not even going to entertain it. You know what I mean? Because when I hear, well, if they do this, then maybe I do that. I'm trying to resolve this. But if you're not, it sounds like you don't want money, you don't want anything. So let's not even talk about if they give me the money. Okay? Because when I hear that, I think, oh, well, maybe they will take the money. You know what I mean?
Well, I mean, I'm not 100% sure. I'd have to confer with my client. But I remember my client telling me, no deals. We just want the property back. We're not going to go through this for another 6 years.
Okay. Are you both down here tomorrow?
I'm not, but I will, let me see my calendar.
Yes, I am.
But I will make a, I'll make a.
I'm sorry.
I'll bring it, Your Honor, because I have not done anything wrong but try to live as a Black man and do the right thing. That's all I have done. And I keep getting harassed by ACP Nash, and it's been going on for 4 years.
Why? I'm sorry. Why? What was there a lawsuit filed in the circuit court?
Yes.
Against ACP Nash?
It was filed by, I was doing 2-minute background.
No, please don't do that.
Yes, ma'am.
Was it filed?
Yes.
Okay. And what was the outcome of that lawsuit?
Dismissed with prejudice.
All right. This is not the place to, I mean, I guess you could, like try to, this is a landlord tenant docket. So this is not the place to attack how much money, any kind of misrepresentations or anything like that. So either you are going to pay what is owed or you're not going to pay what's owed. And it sounds like you haven't paid what is owed. Now, it also sounds like that the previous judge did give you some kind of credit towards what was owed on the land contract.
The whole crowd, that's the whole thing. This is not just landlord tenants, it's land contract forfeiture. And land contract forfeiture is not, okay, here's the judgment. Land contract forfeiture is a hybrid, almost like a foreclosure. That's why you have a redemption period.
And the redemption period passed.
That's what I'm saying, it's all when you appeal.
All right, show me the law that says that.
Well, I can get it back out, pull it back up.
No, you're not gonna do it now because we are 2 hours past lunch. We're coming back. I want to see the date and time stamped copy of the claim of appeal that was filed in 36th District Court. I want to see the receipt or the waiver that was signed and issued by 36th District Court. And I want to see case law that says that the toll period, you know, that the redemption period is told during the pendency of the appeal. Attorney Bajani, you're asserting something completely opposite of that, correct?
Yes, sir.
Okay, well, let me see the law. I want to see the law that says that. Because I think that does have bearing over whether the eviction is proper, because, I mean, they all play into one another.
And what time would you like to see if Jack can just drop that off?
Well, Attorney Bajani is down here every day, correct?
Yes.
Pretty much. I'm ready to rule on this, one way or the other. And after this next court date, there won't be any more adjournments or anything like that. And sir, you may want to start making arrangements, because if I don't see, if the law doesn't come back in your favor, and if I don't see the date stamped, the court document that I need, you know, I can only do so much, sir.
Yes, Your Honor, I understand that, but I just want to be clear for the record. I just wanted to ask you a question for the record. For me, we got a judgment, immediately appealed. The judge said, I'm gonna discuss and figure out an escrow, and told them about my half. Y'all need to consider taking my half.
Need to consider though, but I don't think you can't order somebody to have a third party pay your, you know.
No, but
Okay.
that's covered in there and the rules that they'll go through. I'm just using just regular, not law.
Okay.
But because he said himself after the judgment that they were obligated to take any funds. He said that. But anyway, the judge says, I'll come back and give an escrow order, if any, but you guys need to think about taking the 25 as escrow. That's what she said. That's the orders that we were given.
Was it an order or was it a suggestion?
You're supposed to come back for her to put in the order, and what she put on the record.
Right, what she put on the record. She said that. So when she said to me, Mr. Campbell, you gotta pay this amount of escrow every month, I paid it every month, like you can see in the computer. There was never an order given to me to pay anything or do anything, and we stayed on it. I got on Attorney Fluker's nerves because I try not to be not considerate, but she was sick. But I'm saying, well, what's going on? Because I'm looking at the register of actions and I'm like, they took my fee waiver, they got everything, but it's never even, not one time even put on the record. But then they put on the record that transcripts is ordered and transcripts is taken. But why would you put that on the record if there's no appeal? Because you can't just pull out another record where there's transcripts on it for no reason.
So I'm looking at the register of actions. You can order a transcript.
Right.
I mean, it doesn't have to be like an appeal on the record to order a transcript. I can order a transcript if I. Well, the register of actions doesn't say that. It just says request for transcript received. And I'm just telling you what the register of actions says. And I do not see anything on here that says any fee waiver was accepted. When was do you see that on the register of actions?
No, that's why I was jumping up and down.
And that's why I need to see a date stamp copy. That's all. I need to see a date and time stamp copy. Do you have a date and time stamp copy, Attorney Bajani? Just wondering if it was served on you. Okay, so Attorney Fluker, how soon can you get those things to the court?
Within the next couple days.
I can't understand you, ma'am. June 15th?
Yeah, I'm here, but not be here, you know, early morning.
Is it in my courtroom?
Okay,
I'm sorry, Attorney Fluker. Okay, I see it with Attorney Zahar. That's a review.
So June 15th.
Can you pull up June 15th? Do you see how, is that right? The calendar? Yeah, like it is? Okay. All right, so so June 15th is a good day for them to come back?
Yes.
All right, I do have a bench trial scheduled for June 15th. Let me. My computer just froze up. Come back at 11:15. I think that goes without saying, but Attorney Fluker, please do. I don't know. I mean, obviously, if you put it in the mail, it won't reach Attorney Rejani. Okay. All right. So this matter is adjourned to June 15th at 11:15 a.m. I will see you all back down here in person. Thank you. All right, we're almost done. We have one more case for the day. Thank you so much to my court staff. All right. Oh, you already gave it. The one that I'm about to call. Attorney Bijani, whatever case law you are relying on, I'd like to know what that is as well.
Sure.
Okay.
Also, they can read the commission report, I can try and support it.
Okay. All right, our last case of the day. Now calling case number 22392586. Mutual Property Management LLC versus Portia Griffin and all other occupants of 3799 15th Street. Is that 16th Street? Let me see.
Yes, 16th.
16th Street in the city of Detroit. This matter is scheduled for bench trial today. May I have appearances, please, beginning with the plaintiff?
Can I know what you about Miss Portia Griffin, who's to my left?
Ms. Griffin?
Portia Griffin.
Okay, Ms. Griffin, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Thank you. You can lower your hands. Okay, so this matter is scheduled for a bench trial, as I indicated before. I have in front of me a dismissal order. I also have in front of me an objection filed by the defendant. Defendant's objections to plaintiff's proposed dismissal. Can you please tell me very quickly, counsel, why you're objecting? Well, let me note that this is not signed by Attorney Ogletree. So are you in agreement with the objections that were filed by Ms. Griffin?
Yeah, I'm advocating on her behalf. So Ms. Griffin is indicating in regards to, today's the day scheduled for trial today, as court indicated. She indicates that the dismissal
paperwork that was filed by the attorney is incorrect. She did file answer. Says she's been doing it in good faith. We filed exhibit list, witness list, exhibits. The plaintiff hasn't done any of those. Court order proof of ownership be filed. Instead, Ms. Griffin was served with a 30-day notice to quit. Further, in regards to this, that there was, in terms of documentation, she's received no documentation in regards to this case since, roughly the same documents that was presented in January of this year. But today, again, still stands no proof of ownership. My client says she's been doing good faith. She asked that, she be allowed to continue the trial, but it's still a violation of due process. I guess we would ask for a judgment, $0, with Ms. Griffin remain in possession.
All right, Attorney Bajani, you filed this motion. Not a motion. Well, I guess it is like a motion. You submitted a dismissal. What is the basis for the dismissal?
Judge, I don't think we really need one, but I can give you a basis for it.
What is it?
The basis here is that my clients no longer wish to rent this property, especially to the defendant, and therefore we'd rather just seek possession of the property. So we hope to dismiss it and then refile the determination.
Attorney Ogletree, I mean, if it's the plaintiff's burden to move forward with the case, and if the plaintiff doesn't want to proceed, I can't make him move forward with the trial.
What we're asking for is just a judgment of $0, because today's set for trial, it should be a $0 judgment. My client is filed by the court.
Judge, we would object to that because that would mean that we fully adjudicated this case, which we're not.
Well, it's out.
And there's no countercomplaint. Had there been one, then in this case would be different. But like you said, if I have the burden of proof, if I just sit here and not talk, or just sit down and not file anything, the court eventually will dismiss the case.
That's true. I mean, he hasn't. You stated that he didn't submit the deed. Usually, when somebody doesn't submit the deed, I dismiss the matter because that means that they have not sustained their burden. So, if they're going to move forward with the complaint to recover possession of property, if it comes back before me, I don't know that it will. He's still going to have to submit the deed and prove that he owns the property before this court grants whatever relief he's seeking. But I mean, he hasn't done, according to what you just said, Attorney Ogletree, he has not sustained his burden if he has not submitted a deed. And that is a grounds for dismissal in most, in my courtroom sometimes. I don't know if a lease agreement has been filed. This is a relatively thick document. And so a relatively thick file. So just as I'm speaking to you all right now, I don't know if a lease agreement has been filed, but I mean, the plaintiff, this is plaintiff's burden, and he doesn't wish to move forward.
My client just wishes that this case has went on since October. She's requesting final determination of this case. I mean, this is
no, he's dismissing the matter. If I enter a judgment against you, even if it's a $0 judgment, it's still going to be against you. You want a judgment in your name, ma'am? No, you don't. I can tell you, no, you don't want a judgment in your name. And that's, I'm not trying to give legal advice, but no, you don't want a judgment in your name, even if it's for $1, even if it's for $0. You don't want a judgment in your name. So I don't understand what is fueling the desire to move forward.
I mean, I guess she's been served with another notice. That's, not before the court yet, but while this case has been pending, a 30-day notice. So it looks like it's going to turn right back around, roughly this month and be a whole nother case and possibly go through it in a whole nother 3 months.
Well, yes, but that's giving you more time to stay in the location, ma'am. I understand. I don't know. Let me see. So from my notes from previously, I think plaintiff asserted there was 11,000, roughly about 12,000 due, and then defendant asserted maybe like 4,500 or something like that. So there's a dispute as to how much rent is due and owing, right? Okay, so if there's no lease agreement in place, even if I did adjudicate this matter and say, okay, well, you pay $4,600 or vacate within 30 days, once you pay that amount, if there's no lease in place, then the next month the plaintiff could still file a complaint to recover possession of property. So
I understand Ms. Griffin said she was to address the board of possible.
yes, Ms. Griffin.
Yes, I was giving a lease agreement with mutual property because they were out of compliance. And they reached out to me, so I helped them get back into compliance, and I do have a lease agreement from mutual. However, and right now however, I did an e-signature, and after I did the e-signature, they presented me with the new lease.
Well, did you get it when you do an e-sign? Don't you get like verification that comes to your email?
Yes, it came through my email.
Okay, so then you have a copy of the lease, right?
Yes, but 975, however, Your Honor, they're asking me to re-sign the lease because they had some incorrections on the lease, like my birthday, you know.
Okay, well, I don't know what's going on with that. All I'm telling you is it makes absolutely no sense for the court to enter a judgment against you, even if it's for $1. Because then there's a judgment in your name, and that is not favorable when you try to apply for credit or, something like that. It doesn't make sense for the court to issue a judgment. And so I'm not going to do it, especially since the plaintiff is dismissing it.
But Your Honor, the first summons that was brought against me from the plaintiff, I've answered and I've gathered all of my documentations, and just to turn around and for him not to submit anything to the court. And
that would be another grounds for me to dismiss the case. So it sounds like he's not prepared. Well, I don't want to say you're not prepared, Attorney Bajani, but what I'm saying is if you're supposed to submit something and you don't submit it, I'm dismissing your case. And so I mean, everything that you're saying, arguing for me to continue with the trial is actually a reason for me to dismiss the case, because it's Attorney Bajani's client, it's Attorney Bajani's client's burden, and they're not prepared to proceed today. And so, I'm dismissing the matter. I'm not going to have a trial. I don't see a file or anything on his desk. He doesn't look like he's ready to go to trial. He's dismissing the case. So it's dismissed. I mean, I don't know. Maybe you can talk to your attorney, and I'm sure you will, Attorney Ogletree, talk to her more. But to me, it just makes no sense to proceed with a trial that will ultimately, because you're not saying that it's zero money owed. You were saying that there was like $4,500 owed. That's what you said last time.
Yeah, that was, I was basing that, I didn't have anything to base it against except for the last addendum that I had, which was 604.
No, the court has made a decision.
Yes, I made my decision. I'm dismissing the matter. I mean, I'm noting your objections, but it's the plaintiff's burden to proceed, and he doesn't wish to proceed. So that concludes this matter. I'm signing the dismissal order now. Thank you all for your patience.
Thank you, Judge. First of all, thank you, staff.
Thank you.
Can I just pick up that dismissal tomorrow?
I just signed it, so if you want to wait, or you can, talk to the clerk about that.
Right up to you.
Okay. All right, that concludes the docket for courtroom 433. Thank you so much, Mr. Court Reporter. And Madam Clerk and Officer. I appreciate you all. Have a good day.
You make a copy.
Don't forget to end the live.
Oh.
Thank you.